Good evening. Welcome to the regular meeting of the Planning Commission. Today's date is Wednesday, September 7th, 2011. Could you report regarding the posting of agenda?
The agenda for this meeting was posted on Wednesday, August 31st, 2011 on the bulletin board outside City Hall and on the city's website.
Roll call, please.
Commissioner Astorian.
Here.
Commissioner Landrigan.
Here.
Commissioner Yasayan.
Here.
Commissioner Sheets is not here, and Chairperson Lee.
Here. And Commissioner Eric Sam, can you lead us in the
Yes.
Pledge of Allegiance? Thanks.
Everybody rise. Please repeat after me. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
And the approval of the minutes. Someone.
I move approval.
Okay, I have a motion.
Second.
Motion and second. So the meeting, the minutes of the August 17th meeting has been approved. Oral communications. I do not see any cards. The oral communications. So on the zoning appeals, there's a case for 3431 Linda Vista Road, but because of the amount of public cards that I received, what I'm going to do is I'm going to switch a couple of cases around to listen to the planning commission items first. Then we'll come back to the appeal case. Let's go with the 7B, which is the Glendale Municipal Code Amendment Case Number PZON 2011-003. We'll look at that first because that is a continuous case, and then we'll look at 7A next. Then we'll come back to the zoning appeals.
Yes, Chairman Lee, for case Glendale Municipal Code Amendment Case PZON 2011-003, we are requesting that this item be continued to September 21st, 2011 without further notice. Actually, I should say with corrected public notice. We had noticing problems, and so we've renoticed it for the 11th.
I move
21st,
the
rather.
continuation of this item until September 21st, 2011 with notice.
Okay, I have a motion
Second.
and support. Roll call, please.
Commissioner Astorian.
Yes.
Commissioner Landrigan.
Aye.
Commissioner Yasayan.
Yes.
And Chair Lee.
Aye. A vote of 4-0. It is being continued till day certain, September 21st. Next item is 7A. Mr. Collin. Let me read the case into the record here. This new business use and standards variance case number PVAR 2011-011, 204 East Chevy Chase Drive. Mr. Collin.
Thank you, Mr. Chairman, members of the Commission. This, as mentioned, this is a use and standards variance case, PVAR 2011-011. It's an application for a use and standards variance to allow the continuation of a non-conforming commercial use in the R2250 medium-density residential zone, and to allow 11 parking spaces where 14 parking spaces are required, also in the R2250 medium-density residential zone. There was a case originally heard, which is on April 29th, and the case number, and this is 20 years ago, was case number 8789, also use and standards variance. The location of the subject property is 204 East Chevy Chase Drive. The subject property has a lot area of 8,957 square feet with 50 foot of frontage on East Chevy Chase Drive at the north and an alley to the south. The lot is flat and contains two detached one-story commercial buildings. The westerly building is 1,516 square feet, and the easterly building is 1,857 square feet. There are 7 parking spaces provided off Chevy Chase at the front and 4 parking spaces accessed off the alley at the rear. Commercial buildings were constructed in 1982, which was Zone C2 at the time. Property has since been rezoned twice, first to R1250, which is a high-density residential, and in 1986 it was rezoned again to R2250, which is medium-density residential. 1990. A use and standard variance was approved on April 29th, 1991 to allow nonconforming commercial uses in this residential zone and to maintain the nonconforming parking provided on the property. As part of the conditions of approval, the grant was valid for 20 years until April 29th of 2011. No floor area has been added to the building since its original construction. However, there have been changes in the tenants. Over the years, the building has been used for office, retail, service, and medical offices. The applicant wishes to maintain the flexibility of uses as outlined within the C2 zone as it was originally developed. The previous use variance limited the types of uses that would be allowed at this address. The approved uses, per case number 8789-UNS, included retail, service, office, and medical office, provided that no more than 2 tenant spaces were occupied by medical or medically related uses. Currently, there are 3 general office spaces, 1 medical office, and 2 vacant spaces. The applicant is proposing to combine 3 of the general office spaces into 1 medical office. This would comply with the conditions of approval for the previous use and standards variance. In addition, the tenant improvement for the consolidation of offices would result in a floor area of less than 2,000 square feet, which under today's code would not require any additional parking spaces. The applicant is not proposing, as mentioned, to add any floor area, and there's no proposed changes to the facade. Previous use and standards variance established an expiration date for which the use was to be converted to residential per the current zoning. The expiration date was set for 20 years from the date of approval, as mentioned, April 29th, 91. While the zoning ordinance requires this property to be residential, the current uses have been compatible with the nearby residential uses. The businesses on the subject property operate at hours that do not impact the residential neighbors. In addition, there have been no reports of noise or other complaints received by the police department from the residential neighbors to the south and the east. The applicant is asking to expand the allowable uses from that previously allowed to include other permitted or conditionally permitted uses as outlined in the C2 Community Commercial Zone. Some of the additional uses, such as private schools, taverns, and billiard establishments, which are conditionally permitted, would negatively impact the surrounding area by increasing traffic, parking, and noise. Staff believes that the use of the property should be limited, as before, to retail, service, and general office and medical office, with a maximum 2 suites that are occupied by the medical office in an effort to continue to not negatively impact the surrounding area. In addition, uses that are conditionally permitted, as outlined in the C2 zone, shall be prohibited at this location, and staff has included these in the draft conditions of approval. Staff is recommending approval of the subject applications, the use and standards variance, and staff believes that all 4 findings can be made for both applications. Staff would like to note one thing in the conditions of approval, just for clarification for the commission. And of the conditions of approval, number 4, we're recommending that a maximum square footage be established for the amount of a medical office, and it's a maximum of 1,600 square feet. That concludes my presentation. I'm available for any questions.
Any questions for the staff?
Yeah, I have a question. There is a mention on page 3 of your report and on the discussion that under C2 zoning, liquor store is allowed, however, will be detrimental or at least negatively impact the surrounding for this area. Isn't it true that a liquor store cannot open there because of the proximity to the school, or that's not so?
Well, that would be considered as part of the requirement. A liquor store does require a conditional use permit, so they could apply, but there's no guarantee of approval.
Is there a time frame for this variance?
We're recommending another 20 years, similar to what was done in the previous application.
And then is there a reason? What's the reasoning behind the 20 years or just having a time frame?
Staff felt that since the building that's there now, with the offices and uses that are being regulated, that it's a compatible use. It hasn't impacted any of the residential areas. There's just multifamily to the east of the subject building and to the south across the alley. And it was felt that since the uses that are being proposed out there and what staff is suggesting as being conditioned still be compatible with the surrounding area and wouldn't be an impact.
So there's like but you put the 20-year timeline to potentially, like, if there's a dramatic difference in the area, you can
come
say
back
this
and-
use is no longer allowed.
Right.
Yeah,
It's like a long-term CUP.
it's something like that.
Any more questions? I have one question. In your condition, you referred to that item number 4, being 1,600 square foot. The combination of 3 general offices that they want to convert to medical office, is that the westerly one, that the maximum size of 1516? So it's under the 1,600 square foot?
That is correct.
That is correct.
And I believe the applicant would be able to speak to that too, because I know they have some suggestions on that. And also, one more thing I'd like to add is the condition for the 20 years, maybe we can make that number 12 of the conditions of approval.
Oh, that is not part of this condition?
Yeah, I didn't see it.
Was that the intention, though?
Yes.
That the 20 years to be...
It's what was asked for and what was approved the last time it came around, so staff is feeling that that's adequate for a subject application as well.
Okay. We don't have any more questions. I'd like to ask Mr. Aram Alajarian to come up.
Good afternoon, members of Commission. For the record, my name is Aram Alajajian. The address is 320 Arden, City of Glendale. I'm the architect and representing my client here, Dr. Zazian, who is in the audience. As staff well presented the project, this is an existing building which was built in 1982. And it was built when the zone was Zone C2, and it was built as a commercial garden-type office, very small. It fits into that environment. Has a post office westerly of it. It's all commercial. We don't know what happened. My client doesn't recall. He owns the building since 1984, and he doesn't recall when the zone change was due and it was processed, to zone this residentially. But the intention from the day one of this building was to be a office building, medical offices. And I have copies of the uses that since 1982, Dr. K's office was there. There was physical therapist, so it was serving the medical uses as well. What we are asking here today, just to grant, and we're agreeing with all the conditions, grant and continue the uses and have the vacant area that we have right now, that there are no tenants actually on the westerly, and it's hurting my client. And his sons would be taking over, to use that as a medical office. So we're asking basically continuation of uses, for 20 years. If you have any questions, I'll be happy to answer you.
Mr. Linder.
So your request is that the whole complex could be used for medical? Is that what you're asking?
No. Right now, we don't want to limit ourselves to the uses, but as staff has limited as only the westerly side is to be used as the medical. And I want to also mention that on the easterly front portion is occupied by Dr. Kazazian, who's got a dental office there and a dental lab next to it. And we have a tenant over there, which is, like a travel agency. We don't want to move her out at this time. But, nobody knows how the economy will, dictate things around. But this is the reality of today, I mean, that west wing is sitting vacant for many, many months. And finally, the family decided to occupy themselves and, to continue the use.
So are you okay with condition number 4, or are you not?
I rather see it. It's that medical could be anywhere in there, because the way the the new strategy of the city planning works also, is reduction on the parking in urban areas will come in soon. It hasn't been approved, but I'm aware of it. So that may help us in the future to, actually, with the lesser parking that we have, to have fully medical. But at this time, we still have a tenant, and we don't want to limit ourselves to only medical. Nobody knows what the tomorrow will bring. We may get a little retail or a travel agency again, or a little office there too. So we want to be open to all those uses. I think square footage is what your question is putting us into the
square footage
certain
doesn't
limit.
say which side it's limited to. It just gives the square footage.
I would prefer not to limit us to any kind of a square foot because it depends on a tenant. But the space is so small. It can't grow to 8,000 square foot medical. You have 1,500 square feet and about 1,800 square feet eastern wing. That's all we have over there. So it's basically that's what it is.
So you are aware that
Yes,
your
we
limitation is
read the
1,600 square
conditions.
foot?
I think
Okay.
it's going to be fine if we continue that.
Thank you.
Yeah. For time
Thank you.
being. Thank you.
Any comments from the staff?
Well, I'm happy to move approval if everybody is
Mr. Foy.
okay with it. We do have,
Yes, Mr. Foot.
If I may read a couple of conditions of approval into the record here.
you may,
We talked about adding one about the 20-year
yes.
approval period, so number 12 would be this permit shall be valid for 20 years from the approval date.
Okay.
And another condition which says that this permit supersedes all prior use or standards variances for the site.
Okay.
Just to be clear that conditions from the previous approval do not apply to this.
So would that be
13.
13?
This permit supersedes all previous use and standards variances for the
Thank you,
site.
Mr. Foy.
Mr. Foy, are there any previous use variances in that property?
Yes, this is the one that expired.
Right.
One that was granted 20 years ago and that expired.
And I assume we, as in real estate, with 20 years, we don't give them any options to renew, right?
Well, we do. They come here. That's their option.
Yeah, there's really no such thing as a renewal. It's all a new permit.
We have a motion here.
All right,
All right,
I move.
Mr. Chairman, real quick, I'm sorry, point of clarification. One of the existing variances that was attached was for a sign variance for a ground sign. I don't know if we want,
And let's just limit to the previous use variances.
so just the previous use variance would be superseded by this one, not the previous standard or variance for the ground sign. Okay.
All right, I'll continue. I move that upon review and consideration of all materials and exhibits of current record relative to use and standards variance case number PVAR 2011-011, located at 204 East Chevy Chase Drive, and after conducting a hearing on said matter, that the Planning Commission hereby approves said use and standards variance case number PVAR 2011-011 in accord with the findings set forth and the two additional conditions as stated.
Thank you.
Second it.
Second. Roll call, please.
Commissioner Astorian?
Yes.
Commissioner Landrigan?
Yes.
Commissioner Yasayan?
Yes.
And Chairperson Lee?
Yes, so for 40420, the case number, what do you call it?
PPA.
Use and standard variance case number PVAR 2011-011 has been approved. Okay, next item is 7B. Oh, we did that already.
See?
Right. No, and we'll then move back.
Do we want to go to this one?
Yeah.
7C?
Well,
It doesn't matter.
how's 7C? Is that pretty?
Fast.
That's Laura. That's you. It's pretty fast. Okay, yeah. Why don't we do that then? 7C. Okay, 7C is a street vacation case numbers 165B and 166B. It's a 4648 San Fernando Road, case number 16B at 460 San Fernando Road. Okay.
Chairman Lee, members of the commission, we have the corner of San Fernando and Pacific. These are minor street vacations to allow for realignment of the road in order to improve the function of that intersection. And so we're requesting approval of these, or actually findings of, that these minor vacations are consistent with the circulation element of the general plan. So that's what we're requesting tonight, just that finding of consistency.
So you're adding to the sidewalks? That
They're vacating. So they're vacating portions here, so you'll have a better turning radius, that's my understanding, improve traffic safety. Right now, it's an irregular intersection, and so what they're proposing to do is to vacate unused portions of the roadway or
of the sidewalk or the street?
the street. It's a realignment. There's a larger project, and this is just part of a much larger project. This is actually phase 2. They're doing a variety of improvements in the area, and this is one of them.
So the islands are going? The islands?
No, the islands
stay.
Their islands stay?
My understanding, and Ruben can correct me if I'm wrong, is that they're vacating portions of the street so they can have a more regular turning radius, and it'll be these are disappearing, and the intersection will come like this, so it'll be more of a regular intersection than it is right now.
Okay.
So the through
So then the
traffic here
islands
will be
do
a
go-
little smoother.
Yeah. I was just trying to figure out, I was going there and then I was trying to figure out how it was going to look. But I guess that's the new, so they're adding to the sidewalk. I guess that's what's happening.
That's my
To
understanding. They're
create-
trying to create a safer intersection
Right.
for turning. There's fewer movements.
Ms. Stadler, there are no parkings, public parking that may be affected by this vacation and adversely affect the businesses around it, right?
I'm not familiar with the entire improvement project. Perhaps Rubik may be more familiar with it, but at this point, all I know is that all they're asking to actually vacate are these sections here.
Okay.
Mr. Chairman of the Commission, Roby Golanian, City Engineer. To answer your question, Mr. Yasayan, yes, the island within the intersection, the old existing island will be gone. We've already started the removal. This will realign the substandard intersection to a more sharper intersection, so the vehicles will come to a right angle stop as opposed to giving yields like they used to. As a result, there'll be some unused portions of the street that revert back to the title owners, fee title owners, and those are the businesses that will be impacted, but they're in agreement with it. It won't reduce any on-street parking. It will impact it and readjust them, but it won't reduce it.
Thank you.
So, question.
Yes, sir.
So what's the plan for well, I find this kind of interesting because this is kind of a unique thing that came up to the Planning Commission. We haven't had this before. What's kind of the plan? Is there another plan for the pedestrian connections made in this new layout? And because I didn't see any crosswalks or anything in the new plan.
Yeah, Commissioner Yasan, there will be crosswalks
Yeah.
at the intersection. It'll be your standard crosswalks as opposed to going through the existing island, the situation they had previously. So it'll be your standard zebra crossing at the intersection.
Okay.
And it'll be a continuous path for the pedestrians
Yeah.
on the sidewalks.
I just thought this was kind of an interesting case. that
It's a
maybe-
unique situation.
Yeah, and it's a really intense intersection. So
Absolutely, yes.
if I don't know if this is an example of a place we can use maybe the Safe and Healthy Streets Plan, some of the recommendations on things to improve
Sure.
sidewalk pedestrian safety in that area.
Absolutely.
I don't know if you guys have a plan for that or not, but
We're working on a plan. It's in its draft stages.
okay, cool.
Yeah, thank you, Commissioner Yasayan. Any more comments or questions? Okay. We're ready to move on. I can entertain a motion here.
I move approval of, where is that? I move approval of, after consideration, case number 165V at 4648 San Fernando Road and case number 166V at 4660 San Fernando Road, vacation of certain portions of San Fernando Road, as shown in the exhibits.
Okay, we have motion seeking support.
Second.
Okay, we have roll call, please.
Commissioner Astorian?
Yes.
Commissioner Landrigan?
Yes.
Commissioner Yasayan?
Yes.
Chairperson Lee?
Yes, with the vote of 4-0, street vacation case numbers 165V and 166V is approved. Okay, now we can come back to our zoning appeal case, which is a conditional use permit number PCUP 2010-020 and standards variance case number PVAR 2010-009, 3431 Linda Vista Road. And I think Mr. Dong.
Thank you, Chairman Lee, and good evening, Commissioners. At this time, I'm simply going to provide you with a brief overview of this project, and I'll come back with the analysis and the findings after the appellant. The applicant is proposing to construct a new one-story, 3,158 square foot single-family residence and an attached two-car garage on a vacant lot with average current slope exceeding 50%, grading exceeding 1,500 cubic yards of earth material, and a driveway slope exceeding 20%. The proposed residence will be constructed on an existing flat pad located at the top of the lot. The lot has an average current slope of 52%, 2% over the threshold, and the applicant is also proposing to grade 1,573 cubic yards of earth material and to provide a driveway slope of 25%. The subject site is a 4.72 acre or 205,603 square foot hillside property located in the eastern portion of the city, close to the Glendale-Pasadena border. This area is known as the Chevy Chase Canyon. The subject lot is bounded by three streets: Buckingham Road, Figueroa Street, and Linda Vista Road. There is an existing driveway accessible from Linda Vista Road, which leads to the top of the lot and the building pad. The lot itself is an irregularly shaped lot and slopes up from all sides with the exception of the east side. The building pad is approximately 13,000 square feet. There are approximately 20 oak trees located on the property and are concentrated mainly along the driveway on the northern portion of the driveway and ring the building pad in some segments in some other portions. Two of the existing trees, which are tree 8 and tree number 20, are proposed to be removed. Again, as I stated, the lot is vacant and has not been previously developed. However, back in 1964, a grading permit was issued to create the pad and the driveway. And that's just the overview.
So let me come back. Did you want to come back with the more detailed analysis?
Yes, I'll come back after the appellant speaks and present his case to give staff overview and not overview but analysis and findings of the project.
Okay, sure. Do you have any questions at this moment?
Do we have access to the grading permit 456 that was issued April 14th, 1964?
I don't have the file, but the file is kept off-site, which was retrieved. I reviewed it, and that grading plan at that time showed a building that was supposed to be constructed in conjunction, but for whatever reason it was never completed and the project was abandoned.
Was the grading that was performed approved by city officials?
Yes, it was permitted.
Off?
Yes, it was signed off, and it was officially closed on October 16, 1972.
So the permit was issued and the actual grading action was certified by a building official and maybe a soils engineer? How was that? How was it closed out?
I'm not sure what the process was back in 1972, but I'm sure it's probably similar to the procedure we use today in terms of certifying the
So there would be a signed-off permit.
Yes, according to our record, it was closed officially. Engineering
Commissioner
records.
Hussain.
Did we get some kind of statement from the fire department or anything about the accessibility to this with the proposed driveway?
Well, when the project was submitted to us for processing, as required, we routed the application to all the pertinent departments for their review and comments, and we did receive 5 comments back. And I have copies for you specifically, if you'd like to see them now.
Yes.
Yeah.
May I ask one
Are-
more question? Oh, go ahead.
Go ahead, please.
This grading permit that was issued in 1964 and closed out in 1972, what was the grade of the driveway in that permit?
That I did not come across in the file. In studying the file, it was not identified specifically as to what the driveway slope was, but what the applicant had determined the existing driveway as it exists today is approximately 28%, 27.7%. So the applicant proposal is actually improving on the existing condition by a tad bit.
Commissioner Estrella, you got a question?
Yes. Mr. Dong, are the comments from the fire department, are they reflected in the negative declaration study and the memorandum that you have with us? Is it reduced to what we see in the neg deck or not?
Generally, the comments that we receive from fire are standard conditions, so therefore they would be picked up through the plan check process for this type of project. The environmental review document is essentially addressing issues that are beyond the requirements that are already set forth in the code for the various departments.
So the fire department manual says provide an access road for fire department. So the planning, or it's believed that that road that's proposed is enough of an access road for fire department. Have fire actually said that's sufficient enough?
It's the board.
Members of the commission, the fire marshal has looked into this project to a great extent. As a matter of fact, he and one of the fire chiefs were at the site just the other day, and the fire marshal will be joining us a little later on during the hearing to be able to answer your questions. So it might be best to, if I can try to get him to come in now, or he'll be able to better answer these questions.
Thank you. So when he comes in, we can redirect the question.
I have one more
Yes,
question.
Commissioner Mandela.
What, in 1964, was there a variance or a conditional use permit that was requested for the grading and the driveway? Or was it just a grading permit issued without any other
There was
planning?
no other planning application tied to that grading permit back in '64.
Just for the clarification, so are you asking that grading permit was just a grading of the pad, or did it include the driveway?
Apparently it included the driveway.
It included the driveway?
Yeah.
Correct.
Okay, thank you.
And at that time, there were no limitations on the percentage the driveway could be?
Our staff historian is here.
Yeah, I was going to get to that later as far as the current regulation, but The only regulation we've ever had up until the two changes was 25%. It's never been steeper than 25%. But I'm not sure when the 25% was adopted. I'm pretty sure it was in effect in 72. Whether it was in effect in 64, again, I didn't do the research for this project, so I'm going back that far. I'm not sure. But we would have checked it if there was an application for a building permit for a house. Then we would have checked the driveway slope at that time. We
But
wouldn't
there
have
was-
necessarily looked at a grading permit.
So the grading permit had no building associated with it? As far
Well,
as-
I mean, they may have shown us some schematic, I don't know, but rather says there was no actual planning application. So I don't know if there was a building permit application or not. But obviously no permit was issued, according to Rather's research.
Okay, thank you. We don't have any more questions. I'd like to bring up the appellant, Mr. Hagobian.
Good evening, Mr. Chair and board members. For the records, my name is Edward Hagobian, and my address is 220 South Kenwood Street, Suite 210, Glendale 91205. I am the designer architect of this project, and we started this project a year and a half ago, and since the certificate of the compliance of this property was not completed, the process, it took the city or us together a longer time to have a hearing about a year later after we submitted this project. When we submitted this project, I was reading the staff report. On this staff report, it says that if we design a driveway, by the way, apparently everything comes down to the driveway issue for conditional use permit and for variance of this project. All the denial reasons are around this driveway issue. So if necessary, I'll go through these 4 findings for each conditional use permit and variance. If not necessary, I can simply talk about this driveway and the issues related to the driveway. When we submitted this project, the staff report, I don't know if it's necessary for me to read, but it says, due to the natural topography in this area, if the proposed project were to provide a code-compliant 20% driveway, additional grading cut of the area along the driveway beyond the amount already proposed would be necessary. This option would necessitate the construction of a series of retaining walls. Some of those walls are expected to fluctuate between 5 to 10 feet. And it goes on and on that if we go with 20% driveway, we'll end up with a very high retaining walls, number of the retaining walls, and grading of, now as our engineers has shown, if we go for 20% driveway, our grading will go up from 1,500 something to more than 6,000 cubic yards. So depending on the report of the city planner, I did not prepare the plans to show what will happen if we do the 20% driveway. And when I read the reasons for rejection of this 2 conditional use permit and variance, it was because we didn't present this. I wish we were told at that time, before the first hearing, to show the drawings that we have today on the board. Happily, we could have prepared that, but however, now we are in a point that we are appealing this, and as you can see, we have so many retaining walls that is not very pleasant for the design board, for the city to see these retaining walls, and however, we end up, the driveway length is about 500 feet, 550 feet driveway. Imagine if we reduce from 25 to 20%, that means 500 times that 5 feet will end up much lower. As you can see in the drawings, may I approach and show you what happens here? As you can see, we have too many retaining walls here. That is not allowed by code anyway. That is another variance. Number of the retaining walls cannot exceed 3. We have 1, 2, 3, 4. And we end up here, we don't end up in the flat pad. We end up with a wall that we have a drawing for that.
Mr. Gobian, yes, the drawings are like
We end up with this wall. We don't end up with that flat pad there. So even this wall is about, I believe, more than 9 feet high. So for all these reasons, having a 20% driveway ends up with this kind of situation that I don't think is pleasant to see. This is the basic issue with the driveway. Now, if, as I said, if we have 4 walls, that's another variance. Another variance for more than 1,500 cubic yard excavation, transporting all this stuff, and not being able to reach to where we want to reach. That's so obvious and basic. If you are going to explain about the fire department situation, then I don't need to speak about that maybe. We talked to the fire. The reason that this hearing was continued was that fire department wanted to solve this once forever. And we had 2 meetings with Jeff Halpert and Doug Nichols. And in the second meeting, they told us that they are okay with this project, and they will have some kind of corrections during when we submit for the building permit. Might include more fire-resistant materials or upgraded sprinkler system, heavy-duty, commercial, or whatever it is. These are the things that might solve our issue. And then they don't care for the driveway anymore. If I have to go to the...
That again? I'm sorry. What did you just say?
For the fire department,
Yes.
right?
Yeah.
Okay. We talked to Jeff Halpert and Doug Nichols, and they told us they don't care for the slope of the driveway to be more than 20% anymore. There are other ways of solving the fire issue, which is upgrading the fire sprinkler system at the house. They can upgrade it from regular system to a heavy, more duty, commercial, or whatever. These are the things that down the road, when we submit the plans for a building permit, at that time the plans will be checked. And if necessary, they will add conditions or corrections to the plans so that we can have the 25% driveway and the house with all these modifications in the sprinkler system or more fire-resistant materials. Like, I don't know, we haven't gone to that point yet, but I don't want to emphasize on it, but maybe instead of having used wood studs, we can use like metal studs and things like that. This is something that we will discuss later. Do I have to go to these 4 findings or just the basic?
Well, you have the time to write your
Okay.
exposure.
Before I forget, when we went to the hearing, some of the neighbors were complaining, and I remember one of those complaints was that neighbor across the street was complaining that his house is built lower than the street. They shouldn't have done that. It has nothing to do with our property. This property, when it is built, it will have a drainage system that at least the water will not overflow and go to their property. If it does now, it will be more better designed drainage system and connected to wherever it has to go. I would like to hear again to the neighbors to see what are the issues. Apparently, they object to this project, but eventually we have a big lot here, even with three streets that Figueroa or Buckingham and Linda Vista. But this is the only direction that we can enter to this property because the other streets are so steep that it's impossible to enter. Now for the findings. For the conditional use permit, the first finding, apparently, there's no objection. The proposed use would be consistent with the various elements, and it goes so on and on. The second one said the use and its associated structures and facilities would be detrimental to the public health or safety. Again, it comes back to the driveway issue. The materials that we will use for constructing this driveway will be kind of rough materials, so the tires will have a better grip to the driveway. And as in the staff report it says, about a year ago we had an approval for a similar project in Sussex State, and it was approved with 25% driveway. While this driveway is wider and that driveway was narrower, and turning radiuses on this project is much bigger and much more convenient compared to the other project. And also, in this report it says, and I have seen this, I have walked through that area many times, many houses, they have excessive slope, more than 25%. A friend of mine is living there with something like 35%. Of course, it's not good, but there are existing houses with that kind of excessive slopes, and there have been no complaint or no accidents or no problem with that. Now, going back to the third findings, the use and facilities would adversely affect or conflict with adjacent uses or impede the normal development of surrounding property. The driveway design has the potential for discouraging use by visitors and occasionally even occupants, thereby creating the potential for increased on-street parking. Now imagine that the owner will park this car in the street and walk 550 feet with 20% slope to reach to the house. I don't think that will happen. Or a guest, I think he will prefer to drive 25%, not to walk the 20% all the way, or walk 25%. The adequate public and private facilities such as utility, landscaping, parking spaces, and traffic circulations measures are only partially provided for the use. Again, everything comes down to the driveway issue. With 20%, we will end up with a straight wall in front of us. No turnaround, no destination to arrive. With 25%, we'll have a nice turnaround, nice additional parking space for the guests there. So that's all I can say. If there's anything else any questions that you have, I'd be gladly to answer.
Questions for the appellant?
How many cars can you park at the house level when you drive up the driveway?
We have a two-car garage, plus we have space to park probably more than 6-7 cars.
You can actually park 6-7 cars other than the occupants' cars?
Yes.
And how wide is the driveway?
The driveway is some locations are a little bit wider or narrower, from 12 feet up to like 16, 17, 18 feet.
Ms. Landgraf.
Mr. Hakobian, when you met with the fire department on their recommendations, they actually recommend that there is an access way. And you said that they indicated that that wasn't of the issue that it has been in the future, and that they mitigate it with other
They haven't mitigated
elements.
yet finished.
However, my question is that if you have 6 cars up there and you have the occupants with their 2 cars and you have a fire, how are you going to get those 8 cars out?
They can drive simply down the road, down the driveway, and they can exit. That driveway, if it's 25% or 20%, it will not make any difference if there's a fire happens there. They will drive down if it's 25%. What's the difference?
Well, the fire department access up there would be blocked by those folks. But I'm just concerned that you said one thing about the fire department. When are they going to come so that we can speak to them? Will they be here?
I will see if they're available to come now.
May I respond?
You sure may.
What they told us that they don't. First of all, fire trucks are not supposed to drive more than, I believe, 6 or 8% slope. Up to 10% is okay, but even that is not practical in city of Glendale because so many houses with more than 15 to 20, up to 20% slope. So they will come and clear these things, but they said the road is not an issue anymore for us.
Did
The
you
road's
see
not an
this?
issue.
Did you see this? The fire department's recommendations?
Is that the old one or new one?
That's the one.
May 13th, 2010. Is there a new one?
Yeah, this is pretty old. It's from last year.
That the date reflects when the application was submitted and routed to the departments throughout the city.
So there's a new one?
No, there isn't a new one. That's the only set.
Our meetings was recently in last, I believe, was in August. So these are obsolete. These are old ones. They changed their decision about requiring a driveway that is for a fire truck is possible to climb up because anyway is more than 10% they cannot drive there.
Commissioner Leonard, you're referring to item H, right?
H. Right.
Yeah, 4H.
Do you have a copy of this, Mr. Akopian?
The old one, yes, I have it.
Well, it's actually contrary of what you said, so, I have a... That's why I'm questioning
Well,
you.
because it's the old one, because during this time we had a long time to communicate with the fire department, and they came up with a different solution that still is not maybe they know what it is, but they told us that they will not object to that 25% driveway for the time being.
Well, Commissioner Landon, let's wait till Fire Marshal gets here to ask
Think
this
so.
question.
Okay.
Okay, and revisit this issue here. Okay. Any other question for the speaker? No. Okay, thank you. Staff?
And thank you, Chairman Lee. As you've heard from the appellant, Mr. Hagobian is requesting that the Planning Commission overturn the planning hearing officer denial of both the standards variance and the conditional use permit. This case was heard on March 30th, 2011, and a decision was rendered on April 19th. At that time, this is a situation concerning this case where you have two staff members within the same division differ in our analysis, and therefore our determination and recommendations and ultimately the decision that was made are different from the staff recommendation. So this is, I guess, it's a healthy discourse. We don't always have to agree on our decision in our understanding and our analysis of each and every project that comes before us.
You mean
So-
just the way that we do it on the commission level?
Correct. No, at commission level and also at the staff level, as each and all other project comes in, we don't always have to agree. I think that opens up elevates the discussion to another level, so it's actually healthy. But in any regards, on April 19, 2011, a decision letter was sent out to the applicant, which was basically a denial of both application. In the letter, the planning hearing officer stated that the required findings for both the variance and the conditional use permit could not be made in support or approve those applications. Basically, just to paraphrase some of the reasons that were specified, one, that the applicant failed to demonstrate that the strict application of the provisions of the zoning code would result in practical difficulties or unnecessary hardship contrary to the ordinance, and that the necessity to perform grading on steep portions of the driveway to meet code was not considered a hardship. Two, steep slopes are common in this neighborhood and are defining features. The applicant did not show the existence of exceptional circumstances or conditions unique to the subject property. Three, that the granting of the variance would be detrimental to the public welfare, as it would increase the demand for on-street parking due to the steep driveway to the property. And four, the purpose of the driveway slope is to ensure a convenient and usable access to the required parking. As I stated earlier, these two applications are related to a proposal to construct a brand new house located at the top of the property. While the subject parcel has never been developed, there is an existing driveway, approximately 500 to 600 feet long, from Linda Vista Road to the building pad. The existing driveway, as I stated to you earlier, is approximately 28% at the start of the driveway, which is nearest to Linda Vista Road. Other segments of the driveway are below 20%. The zoning code limits the slope of a residential driveway to 20% throughout its entire length. In order to construct a house and provide the necessary access, the applicant is proposing a maximum of 25% slope in some portion of the existing driveways. For the most part, the proposed 25% slope will be located at the beginning of the property, closest to Linda Vista Road, and it is not proposed for the entire length. The slope fluctuates along the driveway, ranging from 14.7% to 25%, depending on the nearby topography. As proposed, approximately 120 feet of the entire driveway length will have a 25% slope. Other portion of the driveway will be or below the maximum allowed by the zoning code. So you're looking essentially at two options in addressing the driveway for this project. The first option is to simply provide a 20% slope, while the second, and that option would require the construction of retaining wall that may exceed the number or the overall height. Therefore, in that case, would necessitate additional variance requests just to address the retaining wall. The second option would be to provide a non-code compliant driveway as proposed and construct retaining walls within the maximum height limit of 5 feet along the driveway. So as Mr. Hagobin stated, the height of these walls would fluctuate, and we're talking about a series of retaining walls, not one, but a series of retaining walls, which is demonstrated on the top row, which I have labeled 20% slope and 25% driveway slope. So if you just go across the drawings, you'll see the differences between the two options. If you would like, I can later go up and point out some of the main differences.
Yeah, why don't you, Mr. Dong? That'll be good.
The top row, going across, you see drawings that reflect 20% slope, which is the threshold required by code. As you can see, the retaining wall will be required for pretty much the entire length of the driveway. So you see on one side two retaining walls, starting two retaining walls on either side, and as you proceed further up, you'll find that the applicant is stating that 3 retaining walls would be necessary on one side and 2 on the other side. However, because if you require 20% slope, you're actually grading or cutting into the existing driveway further down. What you will end up at the tip or at the end where it meets the pad, the existing pad, which is at this point. And he is illustrating this picture to state that because of the change in slope for the 20% driveway, you actually be below the existing flat pad, about 9 feet below the existing flat pad. So this option, as shown right now, would not work because it defeats the whole purpose of getting to the pad and the garage. If you actually are below, the 20% driveway is below the existing flat pad. So, and these other drawings here, you'll see section cut through the various points along the driveway. And this one shows, again, as I pointed earlier, 3 retaining walls on one side and 2 retaining walls on the other side. But at the very least, you will find along the driveway 2 walls on either side. This is the 20% version. Now, in order to further develop this option at a 20%, what essentially would need to happen is, this is in discussion with the engineering department, the applicant would essentially need to conduct further excavation or grading of the site. That's why, according to the new calculation, over 6,000 square feet of cubic yards of earth would have to be graded in order to accommodate the 20% option. And this is to account for not only overgrading on the side to build a retaining wall, but in order to solve this break or this differences about 9 feet between the bottom of the driveway at the top and the existing pad, you would have to even grade beyond the existing driveway, because if you can imagine, the lower the slope, the longer of a distance you need to make up for it in order to meet with the pad at the top. So given the condition that it's in right now, this driveway may have to be veered off the existing path to make the distance, or in concert with that would be to extend this further. So therefore you have to grade this and rearrange or reorient the house or the garage, or in combination, and that may or may not work.
So at least that'll be part of the where the garage and the where they drive up to the house. I mean, the house could be at higher elevation, but they're talking about to get access to the carport or car garage, and the patio area there. You need to excavate. So that 6,000 cubic yard includes actually regrading the existing pad.
Regrading the existing pad and also grading the driveway to 20%. Now, below are the drawings for the 25% driveway slope as proposed by the applicant. Here you see that 2 retaining walls will be proposed at the beginning of the driveway, which are reflected in these 2 sections here. Now, the height of the retaining wall range from 2.5 feet to 3 feet. So, as you can see, side by side, there is significant difference between the 2 options. And in addition to the amount of grading, this option would require 1,570 square feet as a total grading, and the top option is 6,294 cubic yards. So, and that's the result of the additional grading. And who knows, in order to solve this issue in terms of the elevation change, additional grading on top of that could be, the situation could be required once, if this option is further explored.
ask staff a question?
Are you finished with your
No,
presentation?
I have more
Please
to add.
continue.
While the option to provide a driveway slope that meets the provision of the zoning code exists, new visual and aesthetic impacts would be created as a result. These impacts would be caused by additional grading, as I stated earlier, of the lot, and the need to construct high retaining walls. These impacts in general are contrary to the overall intent of the hillside design guidelines in preserving the natural features of the lot to the extent possible. A 20% driveway slope in comparison to a 25% slope would provide a level of ease, I agree with the planning hearing officer decision, in accessing the property. However, the difference between a 20% slope and a 25% driveway slope may not, to the untrained eye, be visually noticeable. On the other hand, high retaining walls, particularly those exceeding the height limit, would be easily noticeable and visually obtrusive to the surrounding area, as well as the owners of the property having to navigate this long, winding driveway where you have 2, 3, or series of retaining wall on either side of you. So it creates this almost tunnel-like approach as you proceed up your property. And a 20% slope would require regrading of the entire driveway and would affect many of the oak trees. Right now, the comments we received are based on the applicant proposal to provide a 25% slope. And as proposed, only 2 trees are being removed. Tree number 8 because it's diseased, and tree number 20, it's listed in fair condition. However, staff, when I made my recommendation for this project to be approved, it wasn't a recommendation without conditions. It was recommended approval with condition, and one of the conditions was to keep tree number 20, which was not diseased. And that tree is located in this area, so essentially outside one of the bedroom. And also, in addition to that, the applicant is proposing to construct a retaining wall along the eastern portion of the property. And in assessing and analyzing this project, I believe that that was not necessary. And this retaining wall would require additional grading and also would subject several pine trees to being removed. And based on the scope of work, that was the conditions that was placed for that to be retained and to not go through with that proposed grading and retaining wall. There were other conditions. That the building should be pushed back away from the edges of the building pad from the southern and northern portions. Again, the oak tree, number 20, which is the biggest tree located on the lot, should be preserved and not be removed. Pushing the building back from the edge of the pad will help in protecting this tree during and after construction. The proposed retaining wall located along the eastern edge of the building pad do not appear to be necessary in the site preparation of the lot or construction of the residence and should be eliminated. For the trash enclosure area should be relocated to another area of the pad as to eliminate the need to construct unnecessary retaining walls and to save the existing pine trees. And the 2 other conditions, any changes to the site would require the arborist of record to review the changes. And also, design review approval shall be obtained prior to any issuance of any development permits. So the point I'm trying to make is that when I came to my conclusion, it wasn't without stipulations to further improve this project. Now, again, this is a hillside lot, and this is not the first project before you that concerns a new house on a hillside lot. But what's unique about this property is that you have a driveway and a flat pad. How many hillside lot in the city that we have today that features those conditions? So the intent was there back in 1964 for this lot to be developed. That's why we have the condition that exists today. So we're not talking about a raw piece of single-family property. And the property, as proposed, beside the required standard variance and the conditional use permit, will meet all other zoning requirements. This is a big lot. Now, the applicant is proposing 3,185 square feet as the overall size of the house. Based on the lot size at 4.72 square feet, per the zoning code, the house could be allowed up to 22,560 square feet. So I'm not saying that based on the size requirement, what's required by what's allowed by code and what's applicant proposing should be determining factor of approving the two applications. What I'm trying to say is that in comparison to the overall size of the lot, it makes the project looks like a modest proposal. Now, concerning the conditional use permit, the applicant is proposing to grade 1,570 cubic yards of earth, which includes both cut and fill. And the average current slope of the subject property is 52%. These two items require conditional use permit under our code. Now, a CUP application is not a mechanism generally to prohibit property owners from developing a certain property. It is primarily a tool that requires the applicant to demonstrate that the project is viable and sensible under the condition that exists on this site. So it also affords the public and staff to evaluate potential land use and environmental impact that may be created in the process. That's pretty much all I have in terms of my analysis of the subject property. Now I will turn over Mr. Kraus, as he was the hearing officer on this case, and he may share with you his reasoning and analysis of the project.
Ms. Kraus? Yes, thank you, Mr. Chair, members of the Planning Commission. Rather has given you a pretty complete picture, but let me just give you my perspective. First of all, Mr. Hagopian mentioned some timing and a certificate of compliance. When this application was filed, it was discovered that this was actually an illegally created lot. It was split in half. The existing lot to the west used to be part of this lot. So we can't really process a conditional use permit with that situation. So the applicant was asked to process a certificate of compliance application, which is a mechanism created by the state to allow legalization of already created, illegally created lots. And because it meets the minimum standards in effect at the time that the property was split, we were able to issue, I believe, an unconditional certificate of compliance. Okay, so that caused a little bit of extra time to occur. Just wanted to clarify that. So now it's a legal lot that can be bought, sold, developed. First of all, we got two different applications, and it's pretty obvious from my decision that the driveway was the driving force behind the denial. I am not against seeing development of this property, but because of the standards and procedures we have in place, like the continue to have the conditional use permit process, we have to make sure there's the right degree of quality and safety. Now the driveway, let me go back. You asked about the how long the 25% driveway slope was in effect. I didn't go that far back, but it's certainly been around since the early 70s and probably goes back to at least the 60s. It's only been modified twice. It was modified many years ago. I'm talking about just for single-family development. Forget about commercial, industrial, or multifamily. For single-family, it was changed from 25% to 20% with a maximum 25% for a distance of 40 feet. That was in effect for many years. So this project wouldn't have met the old standard either. Would have been 3 times as long as the 25% rule was in effect. The current rule was established in 2004 as part of an ongoing refinement of our hillside development standards, which most people refer to as the Hillside Ordinance. It was a significant modification in '93. So there was a lot of discussion about a lot of different standards: height, floor area ratio, driveway slope, all kinds of things. So one of the things that was discussed in '04 was the driveway slope. Actually, the staff had proposed a 15% maximum period. This was both the planning staff and the former city engineer. The former city engineer had recommended 15% based on his experience both inside and outside of the city of Glendale. When that came to the Planning Commission, they actually recommended 20%. So that's what was passed on to council, and that's what was ultimately adopted in the spring of 2004. Again, the main idea was greater convenience and safety based on our experiences of the past. So one of the 4 findings in the variance is the 4th one that has to be in keeping with the objectives of the regulations. I didn't think the applicant demonstrated that. Again, what is the point of changing the code and then the first project that comes along deviating from that standard? Obviously, 25% works to a certain degree. I mean, it was in effect for many years. But the point was, it didn't work well in all situations. That's why we were suggesting the lower limit. And again, it had already been reduced to a maximum of 40 feet for 25% years before that. So the narrower the driveway is, the more curving it is, the more important it is to have a less steep driveway slope. This is a large site, and it's excess grading is not desirable, but sometimes I think more grading can lead to a better design and sometimes even a more sensitive design. The driveway slope standard is one of the less subjective zoning standards that we have. A lot of things like setbacks are just, they're arbitrary. They're visual impact, like 25-foot setback for R1, front setback. What's magic about 25 feet? Well, nothing in particular. It's just a certain distance. Whereas a driveway slope has a basis in reality as far as people's ability to drive different vehicles up and down the driveway. So again, I didn't think the applicant convinced me that this was a safe project or a convenient project for future owners, residents, visitors, delivery people, etc. So the fact that this has already been graded to me means that this site actually has an advantage, not a disadvantage, compared to what you would have today had that not been graded back in the 60s. The applicant made the point that, well, it's either a less steep driveway or taller retaining walls. And back when we were refining a lot of these standards in '93 and beyond, pretty much the community wanted everything. It wasn't a matter of sacrificing one standard for the other. But even if you try to do that here, it seems to me the more quantifiable standard is more important. The applicant didn't provide the kind of information he's providing today, so I didn't get to see what the alternative would look like. Frankly, based on his design, it's not as bad as I was led to believe. It's true there are more than 3 retaining walls in a row. However, based on the design, it certainly doesn't have the kind of visual impact that 5 retaining walls would have. And if you did a little bit more grading, maybe you'd need even less retaining walls. You could shave some of the landscaping differently. Again, I don't know how many trees you would lose with the new design. Again, I'm with Rather as far as saving that one tree that they were proposing to remove, so it's not like they were trying to save the most important trees. And again, if you need to get your access to this property for safety and convenience reasons, you may have to just lose some oak trees. I don't know that the applicant is telling us with this revised design how many oak trees we'd actually lose. Then the issue of the 9-foot wall at the end. So the revised alternative plan, the 20% driveway slope plan, really isn't totally resolved because it's obvious that you'd have to lower the pad and in order to make the garage work and the turning area. But maybe that's okay. I mean, after all, they pretty much chopped off the top of this ridge anyway. The neighboring properties mostly have pads, so maybe in this case, more grading would result in a better design. But my job, based on what I had, wasn't to redesign the project, and it's not the Planning Commission's function either. I made the decision based on what I had at that time. And again, the main things are that this isn't unique. There are a lot of steeper, more difficult to develop project sites that have managed to comply with the code. And again, this is a really long driveway, so it's even more important to have the 20%. And as I stated earlier, staff really wanted to have 15%. That included the previous city engineer. The conditional use permit, again, I didn't get into some of the details. I would have liked to have seen some design changes, but again, because I didn't want to redesign the project and condition it that they, like approve the CUP and condition it that they have a conforming driveway, because I wouldn't know what that looked like. So my only choice was to really deny the conditional use permit as well. But I think there are a few changes, as Rather pointed out, that could have been made in this design. So I'll stop there and ask if you have questions for either one of the staff members here.
Questions to either Mr. Krause or Mr. Don? Yes, Commissioner Landrigan?
When you look at the plans, either of these plans, the drainage of this side is affected through the grading, and 25% grade allows for an increase in velocity and carrying of water from the top down to the bottom. It's now will be impervious as opposed to being pervious. It'll go underneath oak trees. It'll impact the trees because it'll be graded underneath it. Do you require anything that deals with the changes in the drainage system for part of the planning, or is that later?
No, that would strictly be engineering, although it's a factor in the decision-making. Obviously, if there are drainage issues pointed out as part of the process, then we would deal with them between, the details would be worked out by our engineering department, but certainly if they pointed out there was a serious potential water runoff problem that was a result of this design, we would obviously not want to approve that design or condition it to be different. So again, I didn't have to get to that point because I couldn't make the other findings related to the planning part of the zoning part of the standards. But yeah, I think somebody did testify that they were concerned about runoff running across Linda Vista as a result of the extra paving and slope.
But at the same time, there's other properties with the same slope around there, right? So
The same
some experience
driveway
with the,
slope or the same property slope?
The same driveway slope or more? Is that
Shouldn't
true?
be more.
But there's other properties with the same driveway slope. Is that true?
I'm sure there are. 25% was the rule for a long time, so there's got to be. I I don't know whether they're around there or not. Some of the newer developments that have the 70s and later subdivisions, or even some of the 60s and later subdivisions with 4,000 and 5,000 square foot pads, don't have the steep driveways because they were either shorter driveways with larger pads, or even the flag lots. A lot of them were graded at 20%, and so most of them probably have a maximum 20% slope, even though 25% was the standard. I mean, generally with rough grading for 60s and 70s subdivisions, usually engineering didn't want to see the rough grading for the driveway portion greater than 20%. So usually by the time they got to the finished design, the driveway was not too bad. And there's some newer ones around there. You'll hear from some of the neighbors sort of upslope there that I doubt have anywhere near 25% driveway slopes. But obviously some in the neighborhood do, sure.
Mr. Foy, you had a comment?
Yeah, just in relation to the previous question that Ms. Landrigan had about drainage, I would like to add that there was a consulting arborist on this project who submitted his report to the city arborist and who approved the report. And the consulting arborist made a recommendation that concrete block pavers should be used for driveway material, not a solid surface. So that goes a little bit towards the question you were asking.
And actually the revised 20% alternative does have a section that has pavers shown. Yeah, right, where you can see the different
So the
pattern.
25, but the 25 slope doesn't?
No.
It's not.
No, it would.
The original plan doesn't, no.
Okay, the consulting arborist report contains some recommendations which would need to be incorporated into the final design. And one of those recommendations is to use pavers.
For the whole driveway? Or just underneath the oak trees?
I'm not certain about that. I don't know if do you have that level of detail, rather?
Yes, the determination was that to protect the oak trees while the project is being under construction, and in the future is to use pavers under where most oak trees are located, not throughout the entire length of the driveway. However, our code also requires that the first 15 feet of the driveway be decorative. So that could essentially be pavers as well.
So that's something that could be added
To the
afterwards.
Correct. That could be made a condition if the commission is inclined to.
Any more questions? I have a question. Mr. Kraus?
Yes.
When you mentioned this 20% slope versus 25%, obviously, whatever prompted it, from going from 25% to 40 feet and then down to 20%, now even looking at 15%. I'm assuming that it was based on the safety factors, safety features of this driveway having a slope. According to Mr. Dong, with the naked eye, is not really, you cannot tell, the slope difference. What I want to know, and I think many of our commissioners will really, what are we compromising here? If we go from 20% to 25%, is there a really safety issue here? Because what I'm hearing is that, I guess we'll have a fire marshal up here too, is that whether it's a 20%, 25%, fire trucks cannot get access up to the property anyways. So from that sense, it doesn't really make any difference whether it's a 25% or 20%. But, this is kind of unusual where we have two case planners presenting your cases here. But what was it that drove our, ordinance to get tougher on the slope here? And what are we compromising if we go from 20% to 25%?
Well, the objective, again, it was further refinement of hillside development standards. A lot of the standards we have were based on negative experiences by staff and the public and commissioners and council members of the past. Didn't like what they saw, had problems with the previous standards, either house size, height, driveway standards, landscaping standards, grading standards. And there was this massive overhaul in 1993, which we called the Hillside Development, or the Hillside Ordinance. And again, the discussion has continued, and we've made refinements in the code. We've made changes to design review standards, added things. It's all part of the refinement process. And the driveway was, again, based on safety and convenience. We had some, again, the previous city engineer had some real-world problems in Glendale and outside of Glendale. The planning staff had some borderline projects. I remember one that was the subject of a variance or two, and it's possible they might not have actually followed the plans 100%, so it might have actually been a tiny bit steeper in one little section. But this one project, they actually just parked it. This was a new house. They ended up parking in the street and wanting to convert their garage to livable space. So they actually did it and got caught. But, well, our driveway's too steep. Can't use it. And it had a fairly tight turn right off the street. So, and there have been some others, too. It's not that 25% can't work. I mean, if you have a short driveway, 25% straight, not too bad. I mean, with transitional curves. You can't go right from level to 25% to level. You have to have the transitional curves. I think if I remember correctly, a prominent local developer actually slipped and broke his leg on his own 25% driveway many years ago. So and you've seen some of the older driveways, they have this really scored or roughed up concrete so that the tires can get better traction. That's the kind of stuff we don't want anymore. We want more projects like were being approved with newer subdivisions, but not necessarily with that amount of grading. We started approving in the 60s, actually in the 50s.
I don't know if you can expand on the real world cases where, that drove, from 25% to 20%. I don't know if you can cite those cases.
Well, I can remember a couple of them. I don't remember the addresses, but they were situations where parking spaces, garages weren't as used as they should be because people had difficulty getting in and out of their garages. I mean, you can see them. Sometimes they're still visible. We did a comparison of other communities back then in '04, and I don't know if anybody has 25%. A number of them had 20%, some had 15%, which is what we were shooting for. Some have a combination of 15 and 20%. Maybe they had to average 15, but no more than 20 at any point, whatever that means. Most communities don't have 25% and haven't had 25% as a standard in this general area for a long time.
I guess I was kind of shooting for if you go from the magic number 20 to 25%, during the heavy rainy days, all of a sudden your car start to slide down.
It could if you have really smooth concrete pavement and you've got a tight turn, your tires are a little bit worn.
You're a bad driver. You're
a bad driver. You might want to park.
So long as we're hypothecating, we better.
No, I mean, obviously, if you have a four-wheel, if you have a Jeep or something, four-wheel drive Jeep, and it's short wheelbase, it's not a big deal. But you have all kinds of people using these properties, and it's not that it's always physically impossible, but we're trying to make it so that we have quality hillside development, and part of that is having adequate off-site parking so that narrow streets aren't as congested as they might be if people wanted to park on the street. Again, the owners probably wouldn't do that. It's a long way to walk, but how about an ambulance? I know a fire truck, big fire truck, isn't going to likely to go up there, I don't think, but you might have an ambulance having to go up there. So again, it comes back to the findings. The burden of proof is on the applicant on a variance finding, and this property just isn't unique with regard to driveway slope situation, nor do I think it's meeting the fourth finding, which is meeting the intent.
Before we go to the public comments. I'd like to bring up Fire Marshal because our commissioners have some questions for him.
Evening, Chairperson Lee, members of the Commission. My name is Jeff Halpert, the Fire Marshal. I want to apologize first for not being here earlier. Hope I didn't cause any consternation. I'm not being present to answer your questions, but I'll try to clarify anything I can for you at this point.
Yeah, just to clarify, there are some of the things that the appellant has, made a statement in conversation with you.
Yes.
That was contrary to some of the reading that we have in front of us. So we wanted the clarification on that from you. So, Ms. Landrigan, you can go ahead.
Do you have a copy of
I have it back in my
turned
desk.
in 2010?
Yes.
All right. And afterwards, the applicant can correct me if I'm wrong. I'm not trying to misrepresent you. But Mr. Hagobian said that if we are looking at item number 4, access and egress, specifically D and H, which you have circled, he said these are no longer very important to the fire department because you don't go up to the house.
Okay, in general, that's basically true. These are our typical comments. Some of them are code language right out of the fire code. And at an early stage such as this, at this time, we will circle issues that we see right away as needing further discussion or further investigation. But as the project progresses, we can further detail these, and sometimes in conjunction with the applicant, we can develop some kind of mitigation for some issues that may have a practical difficulty in complying with. In general, our operations staff will not consider driveways as fire apparatus access roads. They need the driveway for access, but they will typically traverse them on foot. So they will typically stay down in the street, and they will travel up the driveway on foot in order to respond to the house. Once they go up there and they see what's going on and they can assess the situation, they may decide to drive up, but they, generally speaking, avoid driveways in general for many reasons.
In that situation, it says also here that you would have access for water within 150 feet, is that right?
That is correct, and that is also another standard.
600 foot, so you would have to have access to adequate water at the top of a hill that would...
Well, the 150 foot, I'm sorry to interrupt, is not for water. It's a standard access requirement.
Right.
So generally speaking, we will look at Linda Vista as our fire apparatus access road, and we will look at the driveway as if it's a walkway. We will mitigate the standard 150-foot code language with features that will offset and mitigate that distance. And one of them that Mr. Hagobian mentioned was an enhanced sprinkler system, for example. This has a direct correlation as a mitigating factor, in our opinion.
So I saw that those were called out here also. But what about access to water? You would not need access if you were going to go up there. You would...
Right. We are depending on the public street and the public water main and fire hydrant system for our water.
Regardless of how far away it is from the structure?
Generally speaking, and in this case specifically, yes.
Okay. My second question is, the fire department requires a minimum 100-foot clearance from, or is it a 200-foot clearance?
100 feet.
A 100-foot.
Correct.
Does that mean we will remove any oak trees that are in that 100-foot radius?
No.
So oak trees are exempt from that?
As long as they're maintained properly, they can be within the 100 feet. And we don't landscape 100 feet. We will often use fuel modification in that 100 feet. So it depends on the situation, if it's a cut slope, a natural slope. In this case, there's some natural slopes that we would, if I'm not mistaken, the proposal shows landscaping. During plan check, we would work with the applicant. Those areas we would probably prefer to see a fuel modification as opposed to landscaping because of erosion issues. So those details we will get during plan check.
My next question is on item number 3, high fire hazard area. Since it is located in a high fire hazard area, all of the things that you talked to me about just now are only the requirements you have for that, which is our landscaping, brush clearing, and enhanced
Fire sprinklers?
thank you.
Yes.
Sprinkler systems, right. So that would abate any of the concerns of having this in a high hazard fire area.
In addition, what these requirements are calling out, specifically D, David, under item 3, the California Building Code has a special provision for construction requirements in the high fire hazard area for ignition-resistant materials, construction methods, et cetera, and approved materials. So we were simply calling that out as a requirement, which the applicant fully expected, but this project would have to meet those minimum prescription standards in any event.
Okay.
Yes, Commissioner Isaiah.
Someone had submitted press release from your fire department in June 2011, and it said that there was a fire and access was hampered by a steep and extremely long driveway.
Okay.
So do you believe the mitigation measures that's happening for this site will allow, or what's proposed will allow easier access? Or is that just a given for that area that the fire department has to deal with?
I guess yes to all of those. Those are all perfect points that you summarized very eloquently. One of the differences in that tragic fire on Linda Vista is that house was not fire sprinklered, and this house would be fire sprinklered. Had that house been fire sprinklered, there probably would be no press release. There would have been a fire department response. They would clean up, and the residents would probably go back to sleep in that same house that very night. The driveway is certainly a challenge, and let me make sure that I am clear. We are concerned about the driveway. We are concerned about access. It is definitely not this is not considered a desirable design. It is a challenge. But can we service it? The answer is yes. We can service it, but yet it is a challenge, and it is a concern. But we feel that it is still within the envelope of serviceability.
Marshall, would what the general practice is, which is not going up the driveways with the apparatus and so forth, would it have changed if the slope was 25%?
Or 20.
Or 20?
More than likely, no. It might be of assistance for a rescue ambulance, for example, but a rescue ambulance can traverse a 25% grade as well.
In rainy weather and everything like that.
Those conditions are unforeseen, so I can't guarantee everything, but we know that it's rated, they are rated to be able to traverse it, a 25 and even greater percent.
With bad tires and lack of...
But we don't have bad tires in our ambulances. And we schedule the rain, so.
Rain puts out the fire.
It's a good thing.
Any more questions for the fire marshal? Well, thank you very much for coming in.
Okay, thank you, and I'll stay present in case anything comes up. Be happy to answer anything further. Thank you very much.
Yeah, thank you. Before I ask Colin to come back for rebuttal, I have a question to the staff. Some of the conditions that's been mentioned here with the enhanced fire sprinklers, with the different, composite materials for the driveway to give a better grip, for the tires. All those, have that been included in as a part of the condition, or is that something that we need to develop today?
Those items that you just mentioned have not been included as the proposed condition, but they could definitely be made part of the Commission's conditions.
Okay, thank you. You have any more questions for the staff? No. Okay, you have a chance to rebuttal.
Should we do community comments first and then?
We need to hear from the public first.
Oh, okay, I apologize.
Okay.
Can you take a seat, please? We would like to get public comments first before I bring you up for the rebuttal. Okay. Thank you.
So, shall I wait for...
Yeah, please wait.
Okay.
Yeah.
Mr. Chair, can we take a 3-minute recess?
Yes, we'll take a 5-minute recess, but before I do that, because I have so many public comment cards here, I'm going to limit each speaker to 2 minutes. Now, also, I'll ask you to, if you are speaking on the same subject, please refrain yourself from repeating same concerns. And if you have, new evidences or new concerns that you'd like to add, then please do come up and say it. Otherwise, you can just waive your, right to speak here. But again, I'd like to limit the speaking time to 2 minutes per each speaker. So we'll take 5-minute recess. Thank you.
We're on.
We're back from recess. This is the Planning Commission meeting of the September 7th. We will now go to public cards. We have Mr. Dan Hayes, followed by Mr. James Murphy.
Good evening. My name is Dan Hayes, and I live at 3434 Linda Vista, which is across the street from the proposed project at 3431 Linda Vista. And I've lived there for 24 years. My first concern is the potential for flooding, rock, and mudslides from the long driveway in the property. The driveway's steep, and it directs all the rainwater off that property into my property, which is right above where the driveway comes in. It also then joins the water coming from all the way to the top of Figueroa, so the water is compounded by the addition of that water. Even though the city built a berm in front of my home and driveway, I still have to maintain sandbags and boards to protect myself against running water coming down that driveway and coming down Linda Vista. I understand it's going to be handled at a different level, but I want to get of record my concern. There are times when the water actually runs all the way to the midline in front of my property, 7-8 feet, with a combination of water. I'm opposed to any new development that does not effectively and efficiently direct the runoff water to storm drains and or culverts coming off that property. We've all seen the flooding and rocks and mudslides in our area occur from aggressive weed abatement and altering of the natural terrain or improper land development with improper drainage. There is a reason we have established the hillside ordinances, and they should be enforced. We all know what happens when we allow variations concerning grading, slopes, and drainage. We all end up paying and suffering the consequences at a later date. The next area of concern is my ability for the fire department to manage our fire risk.
Please wrap up.
Okay. And lastly, we've had a number of accidents, so I'm concerned about the management of any traffic and construction. We've had 2 cars roll over in front of our house and 3 accidents in the last 4 months.
Thank you. This is just general comment. There have been some complaints of not being able to hear, so when you come up to the podium, please speak into the mic. Thank you. Mr. Murphy, followed by Ms. Schenfeld. You'll pass.
Mr. Chairman, members of the Commission, my name is James Murphy. I am a consultant. I've been contracted by a group of citizens that live in the community. I'm a retired fire chief from the city of Montebello and a retired fire marshal for the city of Compton for 12 years. I was brought into this project to give them expertise with regard to the fire and life safety hazards regarding this proposed project. So I took the opportunity to go up and take a look at it over the weekend. Some of the items that were listed in the fire department's report, which wasn't available online, by the way, so I didn't have a chance to review it. But some of those things I do agree with. I agree with some of the statements that the fire marshal made. I also agree with many of the things that the original reviewer of this, I believe it was Mr. Kraus, made with regard to slope. One of the items with regard to slope that had not been mentioned is the fact that when it comes to slope, the driving issue is whether or not the apparatus can go up and down the slope. I took the liberty over the weekend to contact the manufacturer that made the equipment that Glendale uses. They don't recommend going over 20%. Matter of fact, they'd like it to be within 15 to 18%. Why? Because the vehicles now are much larger, much heavier than those in previous years, particularly going back to 1964. That's 47 years ago. Okay? There are many other issues that come into play. This project is located in a high fire hazard zone. as of January 1 of 2011, that triggers a lot of different requirements. The fire marshal and the applicant mentioned about the sprinkler system. That's a requirement now. It's not an option, it's a requirement. But that only has to do with if the fire is inside the house. What if the fire is on the exterior of the house? How are you going to get to it? I think it's very, very presumptuous and impractical to ask an engine company crew or first responding crew to do a nearly 1,000-foot evolution to get holes from Linda Vista up to the pad. The driveway is 603 feet. Add to that at least 200 feet of working line. That's 800 feet, maybe more, depending on the size of the fire. So these are issues that need to be addressed when looking at this project. I understand the commission and the planners have done a very diligent job in trying to address everything, but from what I read in the staff report, the fire and life hazard issues were kind of got the short end of the deal. There was just a very brief comment from the fire department. These are crucial issues, not only to the residents, not only to the first responders, but to the individual who at some point in time is going to buy this property. They're going to have to live with those issues that you make the decision on now. And they have a right to have as safe a living condition as anyone else in the community.
Please wrap up.
So with that being said, I would ask that the commission review this, and I would recommend that you uphold the denial of the hearing officer with regard to this CUP and variance. Thank you.
Thank you, Mr. Murphy. Next, we have Kent Valverde. Willett.
I live at 3333 Linda Vista Road. I'm immediately east of this project. I've lived there since 1946 when my parents bought the property, and I've lived there except for the 9 years that I was in college and law school. That pad was graded when I was 19 years old, and you can see from my hair I'm a lot older than that now. That pad's been sitting there unused all this time, and to let that pad go undeveloped and essentially off the tax rolls is a sin. The difference between a 20% grade and a 25% grade, I think what we've heard in this room is insignificant. Dragging fire line up there is going to be the same no matter how steep or whether that driveway is steep or not. That fire lines are going to I have to go up there manually anyway. My property is just east of there. Although my address is on Linda Vista, I have about 1,000 feet of frontage on Buckingham Road, which is on the other side of the property. I would strongly recommend that you approve the building of this lot, and let's get this lot on the tax rolls, and let's get a nice house up there and help improve the neighborhood. Thanks for your time.
Okay, thank you. Next, we have John Vincenti, followed by Michael Pontrelli.
John Vincenti. I live at the property that borders this project, and I'm against the issuance of standards variance for this project. When we were notified that this variance request, we were concerned about the structure and its occupants could be protected in an emergency situation given the fact that the driveway of the proposed project is longer than a city block, 2 football fields. Not the normal situation. We asked ourselves, how is a fire or paramedic truck going to make it up here quickly and suppress a fire or provide emergency life-saving procedures? And to verify our concerns and those of our neighbors, we contacted several veteran firefighters, on-the-ground guys that are first responders. They visited the site and independently agreed with our assessment. Got a problem here. They unanimously voiced their opinion that because of the restricted access, long, steep, narrow driveway, it would be nearly impossible to quickly extinguish a fire in this high fire zone, which is surrounded, incidentally, by 15 acres of brush and heavy brush and trees. Fire breakout in this location could threaten the entire upper Chevy Chase Canyon and into the cities of Pasadena and La Cañada. They further added that the Glendale City Code is a generous 30% already for a driveway slope. which makes at best emergency event a difficult one to defend. However, the applicant wants 25% grade, making it nearly impossible to defend, keeping in mind border cities, La Cañada, Pasadena, all of LA County, 15% maximum. So these are our concern and of us and the professional firefighters that serve us. The incident down the road on Linda Vista illustrates what happens when we don't have proper long driveways without being able to get access. And then the event that took place in the Hollywood Hills, where the state-of-the-art sprinkler system failed, injured 12 firemen, and killed 1. So we just say don't repeat these tragedies. Let's build responsibly and protect the citizens and firefighters from traffic loss of property. Thank you.
Thank you, Mr. Vincenti. So, Pontrelli, followed by Palma Vincenti.
Hello, Commission. My name is Michael Pontrelli. I'm a resident of 3420 Figueroa Street. I've lived there for 48 years. During that time, I have seen many fires throughout the area, and one such fire occurred around this property in question. I was witness to this property, and the property could not be accessed at that time from the Linda Vista, from the driveway. What had to be done is the fire truck came down on the property of 3365. They went to the front of their house. They ran the hoses along the full length of their property onto the property of the vacant lot to fight the fire. The fire was raging up the hill. There were embers flying. It just was not practical for anyone to be going up that driveway in that condition. Had there been a house there, it's very likely it would have caught on fire by the time the fire department got there, and it's a very serious condition to try to access that property in an emergency situation. Another issue that was brought up was on the driveway to make it rough, for traction, that type of thing. One thing that hasn't been brought up is there's a lot of foliage in the area, oak trees. I have oak trees near where I live. When those leaves fall on the driveway, it gets slippery. And I don't care what kind of traction you have on there, when that builds up, it is slippery. And that length of driveway, unless you're going to have somebody full-time maintain it, it will build up, and it's an issue. And there's no time to be cleaning it in an emergency. Thank you for your time.
Thank you. Palma Vincenti, followed by Kenny Tintori. 2.
My name is Palma Vincenti, and I live on the property that adjoins this proposed project. The City of Glendale consistently lessens, weakens, and violates its building code simply because they don't conform to an applicant's proposal. And the Glendale Fire Department does nothing to bring to your attention the high risk factor you take when making these code exceptions. This is wrong, because in granting variances and conditional use permits, you diminish the codes that were put into effect to assure public safety. I requested a meeting with Fire Marshal Doug Halpert to discuss my mounting concerns for the safety of our community, since I have not been convinced of the fire department's ability to provide adequate fire and emergency protection to the subject property. I was surprised when I was asked to meet at fire headquarters in a high-security area with no one around. I was escorted to a second-floor conference room by elevator, only accessible by a special key and telephone call. It was then that I was told I would be joined by Deputy Chief Robert Doyle, to whom Fire Marshal Halpert deferred. When I brought up my concerns, many concerns, but one about the failure or the potential failure of fire suppression systems, and cited the documented case where Fire Captain Glenn Allen was killed and 12 others were injured, Doyle went into a rage. He yelled, he pointed his finger at me, he told me to stop it, and that I could not use that information, all over an actual occurrence. What is wrong here? Their intimidating, bullying behavior to a concerned citizen is reprehensible. Doyle ended our meeting saying he would not stand in the way of a man building his dream home. I guess he would rather expose his firefighters to the risk of serious injury and even death rather than sacrifice his pension by making a decision that might be unfavorable to a
Mr. Chair, I think
property
we've
owner or
had-
politician. I am stunned by their reaction to my simple questions that went
Thank you.
unanswered. Where's the transparency and accountability in our city government? My queries
Mrs.
have
Vicente?
not been, they've been met with
Wrap up.
resistance and resentment. And please, please be protectors of our
Thank you.
our public safety. I ask that of you
Thank you.
and deny this request. I'm sorry, I was told I would have 3 minutes for my presentation. That was a lot to get in, but everything I told you is extremely important that you know.
Thank you. Okay, next we have Kenny Tintori, followed by Susan Tintori.
Hi, my name is Kenny Tintori. I live at 3441 Linda Vista, which is the house just like south of the property. The applicant has in the past meetings has said it's a hardship because it will cost more to build this house to the existing codes. It's not really a hardship. It does cost more to live on a mountain or in a canyon. It's because we're living on an earthquake fault or in a high fire zone. It's the price we all pay to keep these hillsides safe and beautiful. We have codes and ordinances. They're there to protect the citizens of Glendale and the beauty of the mountains. Go ahead and build the home, but stay within the laws and the wishes of the citizens of Glendale. The slope, 20%. One of the reasons it was changed way back then was to encourage on-site parking. A 25% slope was determined to be too steep to park on. There is no safe on-street parking here. I guess you've never heard of black ice when it gets wintertime. A 25% slope, you will not stop on black ice because I live next door and I've also ran into the street on my black ice, and I'm only at 20% slope. I'll skip the fire department. You have to ask yourself, would you like a house built next to you that's pretty, but not to code? A house that doesn't meet the hillside ordinances? A house that circumvents the law? A house that you feel is in constant danger to yourself and to your family? Or would you like a house that is built to all the codes, that will make it safe to all the dangers that will come to this house? A house that you can leave your children in when you go away and not feel that they're in danger? I know I want the latter. Please vote to reject this ordinance and to uphold Mr. Krause's decision.
Thank you.
Thank you.
Susan Tintori, followed by Greg Guzik.
I'm Susan Tintori, and I live with my husband at the property that's right above the zip code on that screen. And I concur with all of the oppositions, and I stand up for Mr. Krause's decision. I actually love this piece of property. It's just gorgeous up there. But as a reasonable person, I would not buy that property because of that driveway, knowing that it's probably going to cost more than I can make in a lifetime, and because of the dangers, and I would be afraid for my life that fire or emergency couldn't get there if there was a problem. So you've heard all those issues, but I am afraid because I live right next door, and if something happens with a fire and they're having to traverse that 602 feet with the hoses and all that stuff that I don't understand, by the time it takes to get up there, my house could be in very real danger because of the time elapse. But also I'd like to address the construction time while this house is being built, and where are they going to stage it, and how are these big heavy trucks going to make it up and down that driveway? And as you've heard from a previous person, that area, Linda Vista, is very heavily trafficked because there's Arts Center as well. And our mailbox has been hit twice and demolished, and there's been many accidents. It just seems this year that the accidents have increased. So if you've got construction going on and these trucks and these cars whizzing by, I mean, it's not anybody's fault, but it is a danger zone. And then again, if there is an emergency, that just adds to the congestion. Thank you for your time.
Thank you.
Oh, I just forgot to say one more thing. I'm just for obeying the rules because they're there for protection. They're there for a purpose. It shouldn't be an either or. It should be, is it to code or not? Thank you.
Thank you. And we have Ms. Greg Guzik.
I'll pass.
Okay, you'll pass.
Yes.
Thank you. We have Eddie Hayes, followed by Brian Duran.
Can you hear me? Because I'm short. I'm not speaking for myself. I'm speaking for my neighbor, John Muir, who sent a letter, and I'll just read it real quickly. City of Glendale Planning Commission, standard variance. Dear Sirs, on April 3rd, 2010, I voiced by letter my concerns about the subject variance request. I want to take this opportunity to again urge the Planning Commission to address with the Glendale Fire Department their reasoning for not objecting to this variance request. Since my letter of April 3rd, and he enclosed the April 3rd letter, noting nothing has changed on this property. The slope of the driveway still remains excess of 25 degrees. Fire equipment cannot access the building pad area because of the slope and lack of the turnaround capability, and firefighters will still have to drag hoses uphill around 200 yards before they can begin to start fire suppression. What has changed is the reality that what can happen if a fire occurs in a structure that the fire department cannot access. A short distance down Linda Vista Road, a home was lost to fire in July. The Glendale News Press published a report from Glendale fire officials that cited the loss was in part due to the inability to bring timely fire suppression assets to bear on the structure because fire equipment could not access the site area due to excessive driveway slope. The length of that driveway was about 50 yards, a quarter of the length of the proposed project's driveway, and it was downhill. The applicant can claim that finish?
Just wrap up.
Okay. Can claim that the precedent has been set by previous city approved approval of similar variances. A mistake in judgment can happen, but when confronted with evidence of the results of a misinformed decision, I find it hard to conceive that a public body charged with the safety of the property owners and the adjoining neighborhood could make the same ill-fated decision again. I urge you to carefully consider the safety of all property owners that will be affected by your decision. I further request that you direct the fire department to provide the Planning Commission with a viable plan to suppress and control of fire on the building site and demonstrate same to the neighbors should you elect to approve this applicant appeal. Sincerely, John Muir. He lives at 3498 Linda Vista Road, and thank you for letting me read this.
Okay. Brian Duran, followed by Bill Nickel.
Good evening, Chairman Lee and members of the Commission. My name is Brian Duran. I'm a Chevy Chase Canyon resident. I'm also the co-president of the Chevy Chase Estates Association. My purpose here is to convey to you the opinion of the 12-member Chevy Chase Association Board of Directors that this development, we think, poses a risk to the canyon. We've been in the canyon for 75 years, and we are devoted to preserving the beauty and protecting the well-being of the residents. We believe with all of the testimony that's been given and the evidence shown and all of the details that have been outlined by Mr. Duong that we still think there is a risk. Safety systems fail, sprinkler systems can fail. They're not foolproof. We do have difficulties with distance from the fire hydrant all the way up the hill. And the difficulties of the timeline has been mentioned by these other people. Other properties around the area are accessible by driveways or other means. This one is critically different because the access is difficult. Therefore, we urge non-approval of this variance and conditional use permit.
Thank you.
Thank you.
Bill Nicole, followed by Michelle Saffman. You'll pass? Okay, thank you. Followed by Nancy Reed.
Chairman, members of the board, Bill Nickel, Chevy Chase Estates, also on the board of directors of the CCEA, the Chevy Chase Estates Association. All of the things that I wanted to say have been said, so I won't bore you again with those. I do have a couple of comments that I wanted to relate to you. Number one, I've been on the site for a number of times, 2 or 3 times at least, and I found the driveway rather difficult, and I'm not a timid driver. So it was kind of like an e-ticket for those of you old enough to remember e-tickets at Disneyland. And the last trip we had up there, incidentally, the first two or three trips, two trips, were with Dick Murray, many of you remember. This last trip, I was with Larry Barnes, who was then president of the CCEA, as well as the developer, who I believe comes before this gentleman. And he also made an indication casually to us that he was thinking about subdividing the lot. Therefore, I just wanted to say to you, in the eventuality that Mr. Krause's opinion is overturned, I would suggest that you restrict the use of that lot and not allow any subdivision of it, because any houses that would be built in addition to this project would hang over the hillside, particularly to the west, and I think endanger the people downslope from there. Thank you.
Thank you. Nancy Reed, followed by Stuart Reed.
Nancy Reed, live at 3355 Figueroa Street, and I concur with my neighbors with their concerns, and I urge you to veto this. Thank you.
Thank you. And our last speaker, Mr. Stuart Reed.
I'm in opposition, but
You'll pass. Okay. And we'll record that into the record. Thank you.
Mr. Chair, just for the record, I also received today 2 emails from Mary Baldwin, residing at 1131 Oberlin Drive, as well as from Ron D. Werner, president of the Adams Hill Neighborhood Association. Both of these letters, without reading each one, are in opposition of the project.
Okay, thank you, Mr. Dong. Now we'll ask appellant, Ms. Hagobian, to come up and...
Mr. Chairman, how much time I have?
Another 5 minutes.
Well, I would like to ask more because so many people that are objecting, I have to respond to those objections because I have the reasons to object.
Well, present your case in 5 minutes,
Okay.
and then if you have questions or concerns, we'll come back.
As far as I remember, the 3160 Linda Vista Road, the house that was burned, I am hired by the owner to help them to rebuild that house. I was there 3 times inside. This house not only didn't have the sprinkler system, it was built with the wood construction exposed in the outside, not stucco, not fire resistant. And it was so close to the street, closer than 150 feet, that they could easily walk and extinguish the fire, but for some reason they couldn't. So what I'm trying to say that even that house being so close to the street, again the fire happened. We tried all the options to find a solution to build a house here. By the way, that 25% is a very short distance. May I approach and show you where that 25% is? Have you seen this? Yeah, I've seen it. That starts...
Okay. I know where it is.
Yeah.
You want to see that?
No, I think you get better use of your 5 minutes.
Yeah.
Continue. Yeah.
It's a short distance, but it's a must, it's a necessary. The rest is down to sometimes some locations to, I don't know exactly, 16, 15, 14%. So it's not that in the time of emergency they will start to drive with 25%, right in the middle at the end of the driveway. People are talking about accidents happening in this street. It has nothing to do with this property. Water runoff. I'm sure that there is an engineering way of controlling this water. They can have every 30 or 40 feet or 20 feet kind of channel that collects this water, so they will not have this runoff water, which is worse now with the 27 to 28% slope, uncontrolled, unmitigated. This property is vacant. If there is a house there, this property will be under control. Now it's not. Anything can happen there. Some people can walk there, that they usually sometimes they walk there, youngsters or some other people. There's no control. Nobody will stop them. So if this house if this property is developed with a house, there will be a control. The landscaping, there will be a sprinkler system to prevent the fire. Now, if somebody walks there and throws a cigarette and gets fired. There's no control there. There's no landscaping. There's no sprinkler system there. If we approach with the 20%, we'll end up, as you see, with the wall. There's no project here. There's no turnaround. If we want to continue to make 20% and continue, if 9 feet elevation difference we have there, with the transitions, we will need roughly about 5 times, about 50 feet. There is no space left there anymore. Nothing left to build a house there. So as I said, we tried all the possibilities to find a solution. Simply being irresponsible and say, don't build it, we are objecting to that. Because the fire, because the traffic, because other. We have a fire department in this city, and every project goes through that process. If the fire department agrees with that, if they believe that we can control the fire, we can mitigate that, we have to respect that fire department. Cannot ignore them. But as I said, we are here to find a solution, and we tried all the options possible. And if none of those works out, if this medications doesn't help, if we haven't been able to find a solution, then we have to say this lot is not buildable. Any owner of a property has the right to build there. And I have seen this many, many times here in City of Glendale during the design reward processes, that people come and say, I have my house, I prefer this vacant lot to stay vacant, don't build anything there. That's not the way to be. Everybody has the right to build a house there. But we have to go through the process of fire department, engineering department to mitigate every single issue. If they can approve it, if we can satisfy them, why not to do it? The house is not a huge or big house. And they were talking about the fire sprinkler system. We talk about not only upgraded fire sprinkler system, but also fire-resistant materials also. So please consider all these efforts that we have made to find a solution. To have just a small, short distance of 25% will solve all these problems. Otherwise, a grading of 6,000, more than 6,000 cubic yards, plus if we have to continue that, will be close to 10,000 cubic yards. Is this the solution? Obviously, it's not.
I have a question for Mr. Akopian. What about this issue that was raised by one of the speakers? I believe it was about subdivision. Are there any plans for you to subdivide this? And
Not at all.
Is it at all possible to do that?
Just for one single family house of 3,000 some hundred square foot. That's all.
But that was raised by Mr.
I believe, according to the codes of the City of Glendale, we cannot subdivide it, because Mr. Cross can explain that better than I. Don't know that process, but I think it's not subdividable.
I have a question, because Mr. Hagobian just spoke of additional grading to exceed 10,000. I was under the impression that 6,000 cubic yard, the reason for such a large increase was because due to, leveling the 9 feet difference at the end of the termination of the driveway to, the turnaround area and the garage area. So which is correct here?
No, I'm saying that now it's 6,400 cubic yards with the 20% driveway. Now, if we have to be able to continue to find a solution for that 9 feet wall that the termination of the driveway is, we have to continue. We have to grade the rest of that top of the hill to bring it down to have a house there. That means if we bring it down by 9 foot, 9 times such a huge area, that will go even beyond the 12,000 cubic yard. Or the other solution is to continue the driveway, to turn around.
Also, you're referring to actually grading the entire lot, but you could have a split level lot, where it's just a driveway and the
Will not
garage.
have turnaround then. That doesn't solve the other issues. We have to be able to turn around to have extra parking for the guests. The way we have designed has that advantage that they can approach to the garage, park there. The guests can park in that area. They can turn around and go back. If we have a split level, then there is no turnaround. There is no guest parking.
But you are in agreement that it is doable, where additional grading could provide solution.
I don't think it's doable. Even with additional grading, it's not doable.
Okay. Thank you.
Any question?
Okay. Would I have any more? I don't see any more questions. So thank you. Staff, you have any more comments?
Yes. Thank you, Chairman Lee and member of the commissions. We've heard a lot of concerns raised by the neighbors surrounding this property. I just want to state that for me as a case planner or project planner on this project, in recommending the approval, it's not to downplay the concerns. The concerns are valid, but the question is, what is the level of reasonableness? What is that? Here you have a property that has been modified to a certain degree to accommodate a house, whether the plan was to build a house in 1964 when it was graded, or now. We don't know what happened, why a house didn't go in at that time, but I think from my perspective, not only looking at the code and analyzing the project from that perspective, but also what is reasonable. The driveway is long, as you heard, it's about 500 to 600 feet before you get the pad or to the house. The likelihood that a visitor or an owner would park on Linda Vista and walk up that length of driveway is highly unlikely, in my opinion. That's just my assessment. The driveway, again, does not have sharp turns or radii, so that may be an added benefit in this case, beside that being long. Making what the applicant is proposing at 25% is an improvement over the existing condition of 27.7%. And again, the 25% is not for the entire length of the driveway. We're talking about 120 feet long. The rest of the driveway is at or below 20%. So if it was for the entire length of the driveway, that may be a different story from my perspective. And the project is a permitted use in the zone. It's zoned for single-family house development, and it's surrounded by single-family homes. And I also believe that the property is unique to the fact that it has a flat pad. As I explained earlier, how many properties in the city that's located in a hillside zone that has a flat pad on the top of the lot? And in this case, it's a 13,000 square foot pad. So, and given the fact that the zoning code used to allow a 25% slope, will not make this property the only property in the city with that slope. So all in all, I believe that the project is reasonable as proposed, requiring the applicant to meet the 20% driveway slope, in my opinion, would be a less sensitive development, given the fact that you would see all these retaining walls, and these retaining walls are part of the built environment. Built environment lasts for a long time. So whether it's hidden, but someone is going to see it, whether it's the owner, the visitor, or passerby that could see portion of the retaining wall from Linda Vista. So that's concludes my comments, my parting comments, and with that, staff recommends that the Planning Commission overturn the denial and approve both the standard variance and the conditional use permit with the suggested condition as well as any other condition you see fit. And Mr. Kraus, you have anything else to add?
Yeah, I would just say that times change, community standards change. I think over the years the citizens of Glendale have demanded safer, more aesthetic, more functional developments of all kinds. And in this case, I don't think there's anything unique about this site that warrants a deviation from the driveway slope standard. In fact, if anything, it's more important to have the 20% applicable to this longer than typical driveway because of the things that you've heard. So I would still support denial of both the conditional use permit and the variance.
Thank you. Questions for the staff? Then I'll close the public hearing.
We have fire marshal.
Oh, you want to bring fire? Okay.
Yeah.
Please do come up.
I have a question for him, too.
I'd like to response as well. And your absence. I'm not sure how litigation back there.
Sure. Need to repeat the question? It's okay. Okay. Chairman Lee and members of the commission, I'll be happy to try to address that. I don't have the benefit of having specifics on specific incidents, but in a more balcony view, a global perspective, given the condition the site is in now, compared to a condition the site would be if it were developed, we would have fire-safe landscaping for a certain distance, we would have fuel modification, and we would have maintenance. We would also have the benefit of people on site to control the site, which we feel is better than the condition, the site conditions now, which we think would be more fire-safe.
Thanks.
Mr. Historian?
Yeah, basically, Commissioner Yasayan asked the question that I wanted, because the comment was made that what about the fires outside versus inside? We got sprinkler inside. Let's forget about the failure of equipment every single time, but once in a while. Mm-hmm. But outside, there is no difference. I mean, if there is a house in there, it may be a little bit easier to deal with it. If there was no house and there was a fire right now on that ridge, God forbid, how would you handle it?
We would handle it the way we'll address any challenge that comes our way. We'll do the best we can, given the situation. If we have a brush fire, we will attack that brush fire, and we tend to be very aggressive, especially in a WUI area like this, wildland-urban interface. We would have to respond whether there's a house there or not. But again, without a development there, we have hazardous native vegetation. We have less brush clearance than we would have if there was a development. Does the presence of a house make it more risky? I would say no, from an outside fire perspective, because you would have those clearances and some level of maintenance. But again, even without a house, we would still have to respond to that brush fire and still lay those hose lays and still provide a response. There are still houses in the area. It's still a very densely populated area.
So the fire apparatus would still have to be parked down below on Linda Vista and not use the existing 27% slope driveway? Not again, but an officer will have to make his own strategic and tactical decision at the time, given the conditions of the site, given the conditions of weather and the fire behavior. They may put an apparatus up there. They may decide that it's too dangerous. Whether there's a house there or not, there's an existing driveway. They may not take advantage of it. They may decide that it's too risky. So it all depends on the specific situation and the size up and the judgment of the officer in charge. Thank you.
If there's a brush fire in that area, that entire area is a very, very high-risk area. If we had a significant incident coming from Pasadena, for example, which is a very potential scenario, we would definitely be evacuating the entire area, with or without that house being developed.
Just out of curiosity, what is the, as someone mentioned, one of the speakers mentioned that you have a 600-foot driveway and then 200-foot, I guess, additional hose that you need to have 800-foot running across to get to the house. Is that how far from the norm, and how difficult is it to really stage that?
It's definitely a challenge. If you look at other areas of the city, in Glendale we have a unique mix because we are an urban area. We have lots of downtown flatland, which is much more desirable, and we have a lot of hillside development. So all of our operations personnel, are faced with that issue. That long of a hose lay, we do have other houses in Glendale that are even, I would say, worse condition than this. Even streets that are worse condition than these driveways. And those houses don't benefit from the advantages of sprinklers and fire-resistant construction. They're older homes, they're existing, and those are much bigger challenges for us. So,
and you mentioned before that whether it's a 20%, 25%, really, to you, challenges is really the same degree.
yes, we would definitely, the lower the slope, we would be much happier. But 20 to 25, I don't know if that's enough of a difference to make a significant change in our outlook.
Thank you.
Thank you.
Thank you.
Thank you very much.
There was another comment, Mr. Chair, if I may. There was another comment made about mudslides and running water and so forth. Who can speak to that from staff?
As well, engineering staff here.
Chairman, members of the commission, if I recall correctly, the concern was with mud flows coming down the driveway. When the time comes, if this application gets approved and we get the detailed grading plans, we will require a detailed drainage plan as well that will show the conveyance system and the storage system that will have to stay within the driveway and be controlled and either connected to our existing catch basins and storm drain systems or be forwarded onto Linda Vista Drive.
Thank you.
To further on that question, do you have any stormwater structures up there?
Chairman Lee, Commissioner Landrigan, just going by memory, not close to the site.
I didn't think so.
Yeah, more than likely it will have
It would be
to
surface
traverse
runoff and
the
surface.
street and make its way to the nearest catch basin system.
And these concrete pavers, how much do they help having that in?
Pavers generally are pervious and they will help penetrate water into the soil, and depending on the condition of the subsoil, they will definitely help and the runoff will be less.
Now, the 20% slope proposal had pavers proposed on a portion of it. Is there a reason why it can't be for the whole thing, or can that be possible as well?
That is possible. That is possible for the entire length of the driveway, but consideration has to be paid to the friction factor of these pavers because of the steepness of the driveways.
I'm good.
Before I close the public comment, I just really want to be clear on that we explore all the possibilities with this project, and that is that the variance comes to our case, and we will look at all the possibilities. With the 20% slope, we're going to run into a 9-foot head wall there. The appellant stated that it is, he pretty much have to level the whole, regrade the whole thing. Whereas I'm asking the staff, and I asked that question, and that is that can we have a split level, and then where, it's feasible for him to regrade the portions of the lot, to allow, what he's trying to achieve, and then, that you don't have to go into the regrading the whole lot here.
a split level development is possible on this lot. However, as the appellant has stated previously, you would eliminate the possibility or the likelihood of having a turnaround area becomes more difficult. In this particular situation, it's probably beneficial to have a turnaround area, and it was also recommended by the Traffic and Transportation Division. Having a turnaround area nearest to the house or the garage would allow drivers to prevent drivers from backing directly onto the street. Also, that would help in that. But a split level, it is possible under this condition.
Thank you. Yes.
I'd like to ask the city engineer one more question. The size of this lot dictates that this will be a sweepy project. It'll have to have stormwater protection. The amount of construction to move, the size of the trucks, the amount of trucks for this amount of cubic yardage is a lot for those hillside streets. Does the city also require that this type of construction would repair any streets due to excessive overweighting of their trucks, destruction of city streets? And in that same venue here, using construction vehicles on a grade of that size outside of the Caterpillar, which just removes the obstacles in its course, the clearance that is required for these trucks, what would that be? Because I'm concerned that as they would go up there under the canopies of the existing oaks, that we wouldn't have to worry about saving them. They would be gone in a second because of the size of the trucks and the kind of construction vehicles that would be needed up there. So my question is, based on some of those concerns, what would the impact to the neighborhood and to that site be with the amount of construction and grading that we're talking about? Do I have a valid question?
Chairman Lee, members of the Commission, Commissioner Landgren, that is a very valid question. Due to the size of the project and the amount of grading that's going to require, we have in the past made it a requirement and a condition that the condition of the existing pavement be recorded and post-construction be evaluated, and if there is substantial damage to the street pavement, then the developer will have to make the necessary repairs. We have required also a haul route be submitted and approved by our traffic division that will dictate, or if it's not approved, then alter the haul route. I'm not quite sure about clearance from branches of oak trees. We'll have to check with our urban forester, but I'm pretty sure there's a requirement for that, so they won't cut the limbs as they go up the hill.
I do have a follow-up question. One of the the neighbors had concern when this construction is going on and all this, haul trucks are, moving on this Linda Vista Road and hairpin turns. Is there a requirement for the construction crew or somebody to stand on the street to direct traffic?
Chairman Lee, absolutely. When in a situation when the street is narrow, the roadway is narrow, and then 2 lanes in each direction, and there is a parking lane, then there will be a requirement for a traffic control plan, and they will require flaggers to direct traffic, which we have to go around the parked trucks and construction equipment.
Thank you.
I have one more question.
Yes,
this request exceeds the hillside ordinance's maximum cubic yardage. by 78 cubic yards. How many more trucks is that?
7.
7 more trucks. So the impact is 7 times more than what the original guidelines have.
Correct.
Thank you.
We don't have any.
Actually, Commissioner Landrigan, the impact is not 7 times
No.
more. It's not exponential.
No, it isn't. You're right.
It's far less. It comes to about 1.5 to 2%.
If we don't have any more questions, I will close the public hearing.
Mr. Foy was waving at us.
Oh.
That actually is just, there's not a maximum amount of grading. It's just when you have grading above a certain point, it requires a conditional use permit.
Thank you. So, public hearing is closed. Going to deliberation. Who would like to go first?
I'll go.
Okay, Commissioner Yassine.
I think these hillside properties proposals are always really tricky and sometimes very controversial as well. Personally, I'm always not very much in favor of hillside development, period. And there's always challenges that go into these types of properties. At the same time, there's the right to build, the area is zoned to have some type of residential home, and which makes it challenging to find if this is adequate or not. And then I think one of the challenges is this the most, does this make the most sense where they're building it on this plot of land? On the other hand, I think, residents there, and if I lived there, I think I would be scared of all these dangers that are there, and I think the neighbors brought up a lot of legitimate arguments about fire safety and a lot of other concerns that they do have. Looking at this specific property, trying to decide, does this make the most sense? And you have a property with the flat lot on top. It's not affecting any ridge lines, and it already has an existing driveway, and it's been pretty vacant all these years. I think one of the concerns of fire, which was addressed by the fire marshal, made sense to me, which was a vacant lot like that would actually probably pose more of a fire danger than having a site with somebody there. It hasn't happened yet, but someone could obviously go up there at any time, a teenager or someone that might want to cause some trouble, and may actually light up some fire there, or some type of accident there might happen. So I think that actually makes sense to me, where having a well-developed landscape site where somebody's there would be more appropriate than having just a vacant site where there's an easy access to a dark place up top of a hill. So looking at it from that perspective, I think would this development make sense, and would it make sense, I think, to require the 20% or to require the 25%? The 25%, I think it's just a portion of the driveway. And if we were to require the 20%, I think you're going to have a lot, you're definitely going to have a lot more grading happening, and there's going to be a lot more construction activity happening. Just from the residents' point of view, I didn't hear so much complaints about the type of, between 25 to 20%. I think the concerns were really about the fire, safety problems, and there were some concerns about the slopes as well, and then also the construction impacts too. But if I'm obliged to also try to grant the right to build here as well, and given the site is already pretty built to be buildable, I tend to agree with the 25% slope, since there will be less construction impacts happening as well on the site, and you're going to be grading a lot less. There's going to be less retaining walls that are going to be built, and just in general, less construction that's going to happen. So I think in general, to wrap it up, I would support the overturning of this. I think the site currently poses unsafe conditions, even though, I think we've been lucky that nothing's happened there. And I think for the reasons I mentioned, I would be in support of that. I would be in support of the condition to put in the construct concrete pavers, where we've been told that that would lessen the impacts of the drainage problems that they would potentially have. Thanks.
Thank you, Commissioner San. Like to go next, Commissioner Historian, or?
If you insist, sure. Just a comment about my friend Commissioner Yesayan's comment. It's not only teenagers, so let's not cast aspersions on teenagers that play havoc. But I too believe that in this case, after hearing the Marshal, Glendale Marshal, with all due respect, with Marshal Murphy from Montebello, former Marshal Murphy, that I do believe that our fire department is on its toes as far as handling issues like this is concerned. And we have heard testimony that within reason, the 25% versus 20% is not going to make that much of a difference in being able to get the apparatus or the foot firefighters or the experts to that location. Now, years ago, some of you may remember, probably Mr. Nichols will remember, I worked with Dick Murray and Ginger Bremberg. May they rest in peace. We worked on the Murchison tract and the Polson tract. So I am quite convinced and quite sold on the fact of the sensitivity towards the canyon and to the Chevy Chase homeowners. We did away with a huge development on those two tracts, and the city rightfully stepped in and purchased those two tracts for the benefit of the canyon and the greater benefit of the population in the city of Glendale. I will tell you this, though. I am a fervent advocate of personal property rights within reason. Okay, within the reason that the community standards and our codes and variances set for them. One of those permits, one of those availability of being able to make a grievance and to be able to appeal it is the CUP process or the variance process within our codes. In this case, the biggest issue is the 25% versus the 20%. I am convinced that as far as fire is concerned, it is not going to be making the situation any worse than what it is. In fact, it's going to be bettering. Now, the payoff, in my opinion, is the fact that the 20 versus 25% is 1,500 versus 6,000 cubic yard of grading. That, to me, it would be would be outrageous. I would go. This is exactly why I'm leaning towards the 25% in this instance with this house. With that, I also agree with Commissioner Landrigan that enough, if not more than enough, has to be done to be able to protect as many oak trees as it is possible. With that, Mr. Chair, I'll yield to you.
Thank you, Commissioner Historian. Commissioner Landrigan.
Well, let me offer some comparisons here. The statement from Mr. Duong that 20 and 25% is not visible, is not apparent to the visible eye, is actually kind of eye candy, because where you care about a slope is when you use that slope. A 2% slope and a cross slope is used on sidewalks so that you have a proper drainage. But if you are pushing a wheelchair on that, you can feel that slope. And that's a very small slope. So I think that's really very flippant to say that your eye can't tell the difference. It's not your eye that matters. It is the vehicle that is on it. So I would like to say that it's the real determinant of a slope is the safety of a slope and all those circumstances of the safety of a slope. At one time, the medical profession used leeches to heal us. And we could still do that because they were somewhat successful, but we've made changes and improvements. And I think that's what the hillside ordinance was intended to do. To me, the intent was to create a safer environment by basing more restrictive design guidelines. So the intent of the code is the issue that I have here with the finding. It does not appear to me, and I am truly a property rights person. I believe that this house has the right to be built and that an owner has a right to use their property. But I also think it has to be done within the confines. I would also like to say that we say it's just 120 feet length. Well, the majority of properties in Glendale are 120 feet in length, just 120 feet in length. So you have your 25% change in grade for that 125-foot length. Well, if I sat here, I could do the calculations, but if it was 100 foot, and we can actually, we're going to ask the city engineer, and he can tell you what the rise is from zero to the end of 120-foot length. But it's 10 feet almost? It is 10 feet. That's in just a normal road. That's in the 120-foot length there. So it's a 10-foot rise in a normal city lot. So it isn't de minimis. I mean, and I'm not trying to discount the fact that perhaps the 25% slope is the best solution. I'm just telling you to let's think about this in ways that we can see what the impact is and make a decision based upon this. We have flat plans here. This is not a flat land. And most of Glendale is flat in areas, and that's one thing, but this is not flat. If we also look at the fact that the intent of the ordinance is to create a safer environment by making small exceptions, and perhaps this is a good small exception. That's why we're here, to look at all of the different issues. Then I would say I would have a hard time with supporting the CUP, because I think once you keep accumulating these small exceptions, they're no longer small. It becomes large. We've not discussed why it's necessary to exceed the grading and go for a CUP. And is that a good idea? Is that going to affect the neighborhood? Are we also going to say that it's only seven more trucks? It's only a 10-foot rise and 120 feet. Those are the things that I have a very hard time saying only about. And I think we've worked very hard with developers and designers in the hillside area to come up with good hillside guidelines. And I think the 20% is pretty generous, because it's true in the city of Pasadena and the city of LA, it's 15%, and I'm sorry, 20%. I'm flummoxed. So I would have a hard time, because I don't think I could make the finding that the intent of the code is maintained here.
Thank you, Commissioner Landrigan. I think just to answer your question, the comparison was made between 20% to 25%, and then they ended up 9-foot wall there, so I think the difference is 9 feet. I think they already did the calculation for us. There are two things here. One is that, majority of the neighbors here are concerned with the fire safety, life safety of this project. And the fire marshal, pretty much, gave his side of the story, his opinion, the difference between 20% to 25%, and our fellow commissioners went over that. The other concern is that when we grant variances, has all the options been explored, exhausted, to make this project happen without really causing the hardship. That's why I kept coming back and asking that question. To me, really, is it 120 feet of a 25% on this long, really driveway is a concern. But at the same time, when we force this property owner to go to 20%, which will end up in a massive removal of earth here, I think there's more concern there, and I think there's a valid hardship there. So I think in this hearing process, I must have flopped several times, but I'm going to lean towards favoring the overturning of the decision, thus allowing the 25% slope here. Any more comments?
I'll go ahead and move it once I find.
Chairman Lee, before
That's for.
The public hearing is closed.
Okay. So. Yeah, go ahead.
Can I suggest some conditions that
Sure.
you put to it? I would suggest that the city engineer add some construction conditions to it, the typical construction.
Do we have a list of conditions?
They are on the very
Oh,
last
yeah, I see
page
it.
here, 11. Yeah, so that they would be that typical hillside safety conditions, whether there be, mitigated traffic control, a hauling route, a bond, and a
Can we open it up to staff and see if they have a good language for that, for typical construction?
Sure, I think there were
typical
a
safety.
few items that I think not only those, but we talked about some of the drain issues and some
Right.
of the enhanced
Right.
process.
And I want the concrete pavers.
And the pipe pavers and
Right.
so on. So I'm going to open this up for question to Mr. Foy to see if you got all the conditions that.
Sure. If I may suggest a condition of prior to the issuance of a building permit, the applicant shall submit for review and approval by the Director of Public Works a traffic control plan, including a haul route for exported material. And secondly, and I hope I've covered those, what you've asked for there. And secondly, that concrete pavers be used for the driveway in accordance with the addendum to the arborist report to the satisfaction of
This is throughout the entire length of the driveway?
as you wish.
Now, can we add a kind of a minimum amount of concrete paver you can use on the driveway? Or, you say concrete pavers, but
I think you want to
If
meet
you
the
don't-
friction requirement.
Yeah, there's a
for the
specification,
slope.
I guess.
does that have specifications like that? Or, they might just do 5 feet?
Probably the arborist report doesn't get into specifications for friction. We could also have that be to the satisfaction of the Director of Public Works.
Yeah, that'd be great.
Yes, thank you.
If I may, Mr. Foy, do we have a count of the number of the oak trees around the driveway as it's going up and so forth? Do we know? Do we have an inventory of those
the oak
indigenous
tree,
trees?
Chairman Lee and Commissioners, the oak tree report stated that there are a total of 20 trees on the property, but I don't know how many are around the driveway. But most of them are around the driveway, on the edges of the driveway.
And these are all going to be saved?
According to the report, yes. They are all going to be preserved except oak tree number 8 because it is diseased.
Very good. But so then we do have an inventory.
Yes,
We do have an inventory of the oak trees.
The report actually talks about each of the trees that are located on the property and their condition, and and the rating in terms of the health and the well-being of the tree.
Okay, so that should be part of the condition as well.
Should. And I would like to add that an arborist be on site during construction activity and hauling that if anything that affects the oak trees.
What was the previous condition to protecting the oak tree? What kind of condition?
There were 23 oak trees.
Yeah.
20, not 23, 20. 20. Okay. There are 20 oak trees, and the idea is to be able to save them if there is an inventory of those oak trees available. And we want to be working around them, and at least that's one of the conditions that I think it's appropriate and important. And with the stipulation of Commissioner Landrigan about the arborists.
Yeah. And then I think there was an enhanced fire sprinklers. I don't know what that entails. Is it a redundant system? I don't know what it is. But, even property owner mentioned that he is open to enhanced fire sprinkler system. So I guess that needs to be defined a little bit more as to what that is.
Okay, what we could do is ask the fire marshal for more input and impose those conditions as part of design review?
Yes, please.
And then there was a mention. This wasn't mentioned by me, but it was a gift. So I'm going to write on that, Mr. Okobian. There was a mention of if it's appropriate to be able to use metal studs and so forth. So I don't know if that works or it doesn't, but it certainly deserves a look into.
I think he did mention that he will use construction materials that is, fire-rated materials throughout. So I think he was volunteering if it was beyond what the UBC code says. Obviously we welcome that. Yeah.
Thank you for clarification.
Thank you.
Okay, I'm gonna. Any other conditions anybody else wants?
If I may just run down what we have here to make sure we're getting it all.
Sir.
That prior to the issuance of a building permit, there should be a traffic control plan submitted by the applicant for review and approval by the Director of Public Works that includes haul routes. That all oak trees shall be saved to the maximum extent possible, again to satisfaction of the Director of Public Works, because oak trees are under the department. That an arborist shall be present on site during all grading and construction activities that may affect the oak trees. And that the fire marshal shall determine enhanced safety measures to be included in the design review board condition of approvals.
I didn't hear the concrete pavers.
Oh, okay, right. I'm sorry, concrete pavers.
The specification of the arborist.
Which is the arborist's placement.
We'll give the
under
specifications.
trees, but also to meet the city engineer's understanding of friction factor. There's one more thing, is that there is a street condition and recondition plan
Right. That
put
was
in place.
right.
There's one more little thing, and this may be academic mute, but I know I've been told there is no possibility of subdivision of the 4.72 acre lot, but I'd like for that to be as part of, no?
I don't think we can do that.
Commissioner Lee, members of the Planning Commission, no, it would not be appropriate to impose a condition preventing the future subdivision of the lot. That is a separate permitting process that is not before you at this time, and should it be submitted before you, you would need to evaluate that pursuant to the appropriate zoning and development standards that would apply at that time.
Thank you for the clarification.
Thank you.
So we do not have any more comments.
Actually, Chairman Lee and Mr. Foy, if I may get a clarification, I know this wasn't brought up for this case, but when you mention construction activities, does that include restriction on when concrete trucks could be on site doing the concrete work? Are you looking to limit those trucks to be off-peak hours between 7 or to 10?
My concern is I went to Art Center College of Design, and I'm telling you, There are bicyclists that are on this road, going up and down, slowly up, fast down. There are cars on this road. There are accidents on this road, and I think that we need to have a control of access of large vehicles. So I totally agree that that needs to be part of that.
Yeah, I guess I would prefer to leave that to the traffic and transportation folks instead of us trying to determine hours of various kinds of trucks at this point.
Well, does the
Commission could-
planning say that off-peak hours, there will be no large truck traffic to interfere with very small roads traffic?
You would like trucks to be only during peak periods?
You are a very funny man.
We restricted to
Actually,
off-peak.
contrary.
Off-peak.
No trucks during peak
hours.
traffic hours.
So, Mr. Foy, if you can go down the condition one more time.
Okay.
Before, hold on, are we done with the conditions?
What about the conditions that staff is proposing?
We're going to keep that.
Yeah, we keep
Those,
that.
okay,
Yeah,
that
yeah,
will
this
be
is in
part of that.
addition to that, yes.
Yeah.
And I can also assume that you are satisfied with the proposed findings that were included in Exhibit 11 of the staff report?
I know I am.
Yes, yeah, with all those conditions, and this is additional conditions. So can you read one more time?
Members of the Commission, Chairman Lee, I need to make a comment about the last condition. We have a noise ordinance in effect that governs what time construction equipment can start on site. Typical construction, as you may know, starts at 7 o'clock and ends at 3:30.
Right.
And that's when we can limit the hours of operation.
Thank you for the clarification.
Not a second before.
Okay. Okay, Mr. Foy.
Okay, I will do my best here.
7 o'clock is early.
Prior to the issuance of building permits, the applicant shall submit a traffic control plan for review and approval by the Director of Public Works, which includes haul routes, also includes the street conditioning and reconditioning plans, and with the restriction that there be no heavy trucks during peak traffic periods. Concrete pavers shall be included under the oak trees, with the city engineer to review and approve the friction factor of the pavers. Okay, got that one right. All oak trees shall be saved to the maximum extent possible to the satisfaction of the Director of Public Works. There shall be an arborist on site during grading and construction that may affect the oak trees. And the fire marshal shall determine enhanced safety measures to be included in the design review board conditions of approval, along with the conditions in the report.
And I also was told that these conditions should be applied to both cases, and two motions should be made since these are two different cases.
Oh, you mean the CUP and
the variance separately,
Okay.
yes. And the same condition applied to each one.
Well, I don't have that second.
Thank you.
Let's see.
And also we'll close the public hearing, and we're ready for motion here.
I don't think I have that second motion.
Oh, you
The
can just
CUP.
make the first one with that one, and then...
Okay, well, let me make the first motion. So all those conditions he mentioned, they're part of the first, they're part of the second one? Both. Okay, so I move that upon review and consideration of all materials and exhibits of current record relative to standards variance case number PVAR 2010-009 and conditional use permit case number PCUP 2010.
Wait, you don't need that second one. Just make one motion with the...
Yeah. Okay. So, and after located at 3431 Linda Vista Road, and after having conducted an appeal hearing on said matter, that the commission hereby reverses the planning hearing officer's decision and approves the said standards variance case number PVAR 2010-009. Based on the following findings pursuant to Title 30, Chapter 30, 42, 030, and Chapter 30, 43, 030 of the General Municipal Code, with the added conditions as stated by Mr. Tim Foy. That's the motion. Should we vote on both of them together? Should I put two motions out?
Should we make a separate motion here, or separate motion? Separate motion, okay.
Separate vote.
So, right, so we have a standards variance motion here, seeking support.
Second.
Okay, we have second. Roll call, please.
Commissioner Astorian?
Yes.
Commissioner Landrigan?
No.
Commissioner Yasayan?
Yes.
And Chairperson Lee?
Aye, so with 4 over 3 to 1, the standards variance case number PBAR 2010-009 has been approved. Now, someone like to make a motion for the conditional use permit.
Okay. I'll move that upon review and consideration of all materials and exhibits of current record relative to conditional use permit case number PCUP 2010-020, located at 3431 Linda Vista Road, and after having conducted an appeal hearing on said matter, that the Commission hereby reverses the planning hearing officer's decision and approves the conditional use permit case number PCUP 2010-020 based on the following findings pursuant to Title 30, Chapter 30, 42, 030, and Chapter 30, 43, 030 of the General Municipal Code, with the conditions as stated on page 11, 1 to 6.
Oh, no, and the rest.
And with additional conditions as stated by Mr. Tim Foy.
Second.
Okay, we have motion and support. Roll call, please.
Commissioner Astorian?
Yes.
Commissioner Landrigan?
No.
Commissioner Yasayan?
Yes.
And Chairperson Lee?
Aye, with the 4 over 3 to 1. The conditional use permit, PCUP. I lost it. Where did it go? Um, 2010-020 has been approved.
What's next?
Don't we have the environmental to do?
We forgot to adopt the environmental, the mitigated neck deck that's tied to this project.
Which you have to do first, so you have to undo what you just did.
Ooh, okay.
How do we do that?
Now let's go through the motion again, I guess, to
The first motion, I guess, would be to adopt
negative deck.
yes, negative declaration PEIF 2010-008.
Okay, let's do that. Thank you.
So move.
Okay, second. Okay. Roll call, please.
Commissioner Astorian?
Yes.
Commissioner Landrigan?
No.
Commissioner Yasayan?
Yes.
And Chairperson Lee?
Aye, with the vote of 3 to 1, the negative deck has been adopted. Now, do we need to go back to the same motion?
No.
Our city attorney is saying it's not necessary.
Doesn't? Okay, thank you. Okay. So, planning division updates, please.
Thank you.
We would like to have an introduction of Mia Yoon. She's our new assistant city attorney. And I'd like to turn it over to Jillian Van Meiden.
Thank you very much. I'm Jillian Van Meiden, currently the General Counsel for the Glendale Redevelopment Agency. I've been with the city since 1997, and it's my pleasure to introduce to you Mia Yoon, who's been with our office for 5 years as a litigator, and she has litigated several cases having to do with the Subdivision Map Act and is familiar with a number of planning issues and is very excited to get started. Mia, would just like to say.
Thank you, everyone. I'm looking forward to working with you and guiding you all. Thank you.
Welcome.
And I'd just like to follow up and say that Mia and I will be here to serve the needs of the Community Development Department and the Planning Commission on a regular basis, and we together look forward to serving the needs of the Commission. Thank you.
Thank you.
Thank you.
We'll have many more long nights like this. Updates. Do we have on September 17th? I'll be here. I will not be traveling to, out of state, so I'll be here. So you have 4 members here, right?
I believe on the 21st, we would still have 4 members. So we would
21st,
not,
yeah.
on the 21st, we would not have a full board. the concern was consideration of the North Glendale Community Plan on that night. So
Right.
we will have that item scheduled because you continued it to that date, although we fully anticipate it will be continued again to the 17th of October for a special meeting. That would be 5:30 p.m. And I believe we've confirmed with everybody that that time would work.
Right, because Commissioner Sterling wanted to be here for that. So we'll probably continue the case on the 21st.
Right, and on the 21st, you will have a full commission meeting. We have analysis
That's October 21st?
September
September
21st.
Yeah, next one.
Yeah, September 21st, you have analysis of impediments for fair housing, a greener Glendale plan. We have 3 development agreements, and we have a pedestrian sign ordinance. So you'll definitely have a full meeting.
And unfortunately, I'm going to miss on the development agreements.
Oh, and that's your favorite thing.
What is scheduled for the first week of October?
The first week of October, I know we also have another 3 development agreements. I believe there are other cases scheduled. I didn't write them down. So
Because-
you will also have a full meeting that day as well.
I will be traveling definitely on that first October. I'll be in Mexico on medical mission, so
Oh, really?
yes.
We didn't know you were
He's involved with everything.
How cool.
Yeah, restoring visions is what that is.
No other ancillary missions, just medical, right?
Medical mission.
I move to adjourn.
Nice.
Right. Meeting adjourned.
Thanks, guys.